Stay right there. And mostly he fussed about how when he calls the police on a woman in his life, he's the one who gets arrested. Like, imagine that. Imagine that, Mr. Lawson. But he was, hey, Mr. McBurney, you were good to me. Like, you know what? I was just in the room. I wasn't good or bad to you. And he took off. So Mr. Lawson is not on trial on the 24th. His case has been resolved. Which gets us to Mr. Rouse. Is Mr. Rouse here?
He's in the hallway.
Okay.
We're gonna come back to this one. We are working
Close
on this.
Okay. We will come back to it. Mr. Ponder pled. That gets us to Mr. Poole. And Mr. Poole should be on virtually. And I don't see Mr. Miller. And I don't know if Mr. Poole is iPhone. We've got a lot of gills on this call. So we'll hold for Mr. Poole. He was not excused. He just is going to appear virtually. So we'll circle back to that. Ms. Hanholt should be here. Is she here and up or?
She's down.
Okay. Pardon me?
They haven't got over here yet.
The females or people from ACDC in general? No one's gotten here?
And the females, they're not here yet.
Okay, but males are here and they're up. Okay, so we'll hold so that you can talk with Ms. Hanholt.
Thank you, Judge.
Then my guess is I'll get to talk with Ms. Hanholt.
Yes.
Mr. Williams is here and he's up. Everyone is ready to go on the 24th still. Yes, Ms. Wood?
Yes, sir.
Ms. Reimer, you're standing to say yes, not my detective is going to be unavailable.
Staying to address the court, Your Honor. Yes, you're right.
Fantastic. This was the case I was thinking we'd be trying, but we have that speedy trial demand that stands between Mr. Williams and his day in court. So be ready, and I will send an email out to all the lawyers saying here's the order in which we will be calling things out on the 24th, but let's be ready to roll on that one. Mr. Abate, I hope will be here at some point because one, we need to figure out something about Mr. Poole, but Mr. Dandridge, I know, is in play.
Yes, and we are still working on that one. So
Okay.
come back to it.
Ms. Dilligard, what do you know about his whereabouts?
Judge, he should be here shortly.
Okay, great. Mr. Dandridge has two cases. Mr. Gill is on the call. Mr. Gill,
I'm here.
you're here. There he is. All right. Good morning, Mr. Gill. Ms. Wood, you are ready to go on this case if reached?
Yes, that's right.
Okay. And you had a few concerns about discovery, but then my sense was that Ms. Nix tackled those and we're in a good space with discovery?
Yes, sir. I believe all discovery's been completed and states are ready for trial. It's sounding to me like we're not going to get reached on the 24th.
Probably not, and I'll give you guidance, and certainly Mr. Gill needs that guidance because he's in his big truck far away, and he will be here when he needs to be here, but I let Ms. Wood know it was okay for him to appear virtually. This isn't the kind of case I'll likely specially set, but I'll certainly give folks notice you'll see the email, and I suspect it'll be pretty far down the list with some immovable objects like Mr. Williams's case that was movable only by way of trial ahead of it. So that's sort of where we are.
If I did have just a couple of very minor scheduling issues I wanted to address with the court if we did go on the 24th, mostly just when to put witnesses during the week.
Okay.
Since it sounds like we're not going to go on the 24th, I will address this at this time.
Okay. But I'm in general fine having, if one day we have to end a little early because you're out of witnesses because others can't make it physically until the next day. If we can fit it in 1 week case, that's great. If having to juggle means it's extending into the second week, then we probably need to talk about it more. But it doesn't sound like that's what you're wrestling with.
No, it's just one can only go one day and then another could go only in the afternoons.
Okay. All right. Let me check one thing about that week. As a drug court week anyway, so we're going to have a funky Wednesday. I don't know which day that was, but Wednesday morning we won't have trial. I'll be doing drug court. So if we're trying Mr. Frazier's case, that won't matter because we'll be done by then. But thank you for flagging that, and I will keep you and Ms. Wood posted. And Ms. Wood, you'll let Mr. Gill know what's going on.
Yes.
Okay, Mr. Gill, any questions about process?
No, everything's straightforward.
What state are you in right now?
I'm in Ohio right now.
Ohio, all right. If you need to be here on the 24th, you can be here on the 24th?
Yes.
Okay, good to know. All right, do you need Mr. Gill to stay on the call?
No, you're.
All right, Mr. Gill, you're good to go. Titus Murphy.
We would be ready on that case. I do want to talk to him one more time. I did have my investigator go try to show him some stuff, and he said he hired Ed Adams, but I don't think Ed Adams remembers being hired based on our.
Doesn't mean Ed Adams wasn't hired, but you should talk to him, and I need to talk to Mr. Murphy.
Yeah, I can let him know we're not going to get a continuous based on that.
Right. That's going to be tricky for Ed Adams. And of course, this is a case that is rolling along, as you know, on 2 different trial calendars.
Yes.
So it's got double the chance of being reached. We do have the little wild card of Ms. Ford. Did Mr. Luemba ever finally confirm he represents Ms. Ford?
I did, Judge.
Oh my gosh, he's right there. Hey, good morning, sir.
Ms. Nelson, a copy of my intro.
Fantastic. Thank you for being here.
No problem.
Ms. Dilligard is, if she hasn't yet, going to want to talk to you about Ms. Ford and is she here? Is Ms. Ford here?
Yeah, over there.
She's not in custody. She is in custody? Holy smokes. Okay. Ms. Dilligard's going to want to talk with you. So you two should chat. And if you don't mind waiting till Ms. Ford gets here, just so the 2 of you can connect. I think
That's fine. I just have an announcement making Judge Farmer at 9:30 back.
Great, do that, but as long as we see you again this morning,
Yes.
we'll connect you with Ms. Ford, and you and Ms. Dilligard can talk about, and Ms. Cabrera may have gotten you up to speed. Ms. Ford's posture is a little bit different than Mr. Murphy's, it sounds like, but you should talk with the prosecutor. Thank you so much, and thanks for plugging in at the last minute on this case. Mr. Cherry pled, Brandon Baker. Ms. Cabrera represents him, and she's going to be here.
Yes.
She's on her way. We'll talk about that. His co-defendant is a little behind, and so I don't think we'll get to Mr. Baker's case on this calendar. Mr. Boseman.
Let's circle back on that one. I'm going to talk to him and see what he's decided.
Is he in custody?
Yes.
Okay. Joelle Lett.
Good morning, Your Honor. I'm in 62 this morning. This is Kansas Duvernay. He says it's an elevator, so he is in the building, Your Honor. I would respectfully request a continuance. I spoke with the state. Mr. Leck is a 21-year-old, and in reviewing the discovery and speaking with him, there are some mental things that he's being treated on, and speaking with the state, if evaluated, this may be a walking in, Judge. If evaluated, maybe we get something resolved, shorter trial, but we could need some time for him to get that treatment, from his therapist, Mr. West. He's very good.
Okay, all right. So, we'll talk about that.
Thank you, Judge.
All right.
And if we can approach him with more information, I want to.
Right, no, that's what we'll talk about. We can go into the jury room or something and talk about that in a less large group setting.
Thank you.
Okay. Robert Holliday. He should be in custody, not in custody. He's right there. Okay, I can't tell. Pardon?
He was released early this morning.
Oh my gosh, wow. Well, there you go.
So
How does that come about?
I'm not sure. I know he was released at 5 a.m., but I need to speak with him.
Yeah, I bet you do.
And then I need to speak with his Dilligard, and then I'll have an announcement.
Huh. Okay. Does he have other cases?
Yes, yes, Judge.
All right. I'm confused by that, but hello, Mr. Holliday. You should take a seat. Ms. Wood's going to talk with you, and we'll figure out what we're doing. Camille Carpenter.
Morning, Your Honor. Mrs. Carpenter is present. It's going to be negotiated for this morning.
Great.
Most will be negotiated. We're going to go down negotiated on one.
We can do that. All right.
Thank you, Your Honor.
You're very welcome. Derek Rogers. He is in custody.
Yes, I just need to talk with them, but I'm anticipating that being a plea.
All right. And Ethan Brown is here.
I believe we're gonna work this one out today, and then Mr. Lagarde and I are gonna continue working on a resolution for the other cases.
Okay. So we'd get him off a trial calendar, but he'd have other business.
Yes.
And at least one of them has been indicted, so that's coming here.
Now there's 2 indicted and then a couple of other unindicted matters.
Okay, and Mr. Brown is standing here in court. All right. We'll, Mr. Brown, sit tight. Ms. Wood's gonna talk to you and we'll figure out what we're gonna do with that. All right, and I saw Mr. Miller come in. Good morning, sir. And Mr. Poole is on now. Excellent. Mr. Poole, can you turn your phone on, please, or device?
Good morning, good morning.
Good morning. Let me add you. Mr. Miller, Mr. Abate is not here yet. I don't know if he's stuck in another courtroom or just running late. But I'm not gonna make you and Mr. Poole wait around. This trial calendar is just 1 week. And I've got a couple of in custody defendants who are ahead of Mr. Poole's case. So my thought is to not even keep you guys on warm standby, just because I know that involves getting people in from out of state. And so we will likely bump this one. And I know the state is looking into, does it need to get counter experts? Because I think you got 1 or 2 new experts sort of on the eve of the last time this was maybe going to be tried. I'm comfortable saying stand down on this calendar unless you are already ready to go on the 24th with everything. Okay, but you're all right with a stand down? Yeah. Okay, all right. And it just means we don't have to have Mr. Poole come on down here. If all the jail cases went away, we could do that, but I'm reluctant to say come on down in case that happens, because it sounds like we have enough other things to try. So, pardon me?
I'll let our people know.
Okay, do that. And Mr. Poole, Mr. Miller will let you know the next trial calendar that you put on. Okay.
All right, yes, sir. Thank you.
All right. Thank you.
Judge Farmer needs some jobs.
What is
They're trying to do something, with an interview.
Okay.
Staff just came by and said, can she please come on?
Okay. All right. All right, that is the calendar. Is there anyone here who thought they had a case today or a relative who had a case today and they didn't hear it called? Nope. All right, here are my thoughts. Ms. Dilgard, you're gonna be popular this morning, but we do have a plea that's ready. And so I thought we'd take the plea. That would allow some other folks to do some other things. Ms. Wood has a bunch of people to talk to, and it's not her plea, so she can start doing that. So we could start with Ms. Carpenter's plea, and maybe Ms. Rios, you could talk to Mr. Rogers. I don't know who you needed to talk to cement the Rogers plea. But we could do Ms. Carpenter's plea, and then if there's not another plea ready, we could do the bond hearing on Mr. Mender, so we can get Ms. Singleton on her way.
Yes.
We don't have to do the bond hearing on Mr.
No, Mr. Mender, that's easy. I think Mr. Mender was wait.
Right. So we don't need him, we needed you, and you're here. So we can do that.
I have one other, bond motion, but I need to speak with him.
Okay, is that an add-on also, or
It is Mr. Williams.
trying to remember who Mr.
Williams.
Is he, that's right, you had one of each of the 3 defendant cases. So Mender is the Marta armed robbery,
Right.
and then Williams is the shooting next to the Amazon warehouse.
So where exactly?
It is a cut, I got to hear a lot about it from the other defendants. There's a cut between a bus stop and the Amazon warehouse, and this guy was robbed. Yeah.
But I need to speak to, Mr. Williams.
Okay.
Mr. Williams, you can do whatever you want.
Yep. Okay.
I just want to speak to Mr. Williams, and give him a copy of the,
Okay, and then do you have, I'm looking.
Brandon Baker.
Brandon Baker, he's here. he won't be reached this calendar because Ricky Pierce, his co-defendant, is now catching up. He has been given authority to represent himself. So that's what he wanted. He is an American state citizen. He made that very clear in about a 30-minute presentation that poor Ms. Rivers had to take down. And he's ready to go. We just need to get him discovery, but then he can catch up to Mr. Baker. And so probably not the next trial calendar, but the one after, Baker and Pierce can both be on it.
That's fine. Baker's relatively new anyway. Me and Mr. Elias.
Good, okay, he's here. And then Mr. Luemba, I think, ducked down to another courtroom. He's here. And so he's taken over with Ms. Ford, which is great. And so Brandon Baker was it. All right, so we've got your 2 bond hearings and you can speak with Mr. Baker. If I need to tell him why we're not going forward, I'm happy to do that. Just let me know.
We have enough officers to be in the back. You also.
I don't know. But our plea is a bond plea, so I would think that would be okay. All right. Ms. Charles,
Yes, Your Honor.
tell me what you have today.
I have Mr. Rouse with Ms. Wood. She just has to speak to him briefly. Our expectations that that case will be null pros. She just gets some paperwork from him.
Okay. Judge Farmer is really anxious to see you.
Yes. I'm happy to get my 30 minutes.
Do you mind going there and then coming back
I
to
will.
sort out Mr. Rouse's situation?
Absolutely.
Great, thank you. Okay, we'll hold off on Mender till you're back. When you're back, if we're not, we'll turn to that. Thanks.
Can you excuse your honor?
Yes, ma'am. Be ready for the 24th. All right, so Ms. Carpenter, if you and your lawyer would come on up to the podium, please.
Your Honor, I have the plea of guilty form.
Great,
Filled out.
thank you. Oh, we also had an inquiry. Was Ms. Bernard supposed to show up?
Yes.
Is,
She was an attorney.
pardon me?
She was an attorney. She's got.
Oh, Ms. Cabrera is. Okay, great. All right. All right, sorry to keep you waiting there, just seeing what else we had this morning. You ready?
Yes, Judge.
Okay, Ms. Rivers, are you ready? We'll go on the record. This is 24 SC 0038882-01, which means you were reindicted for some reason. Ms. Carpenter, your lawyer has told me that you are ready to enter a plea. Is that correct?
Yes, sir.
Okay. Ms. Dilligard's going to put you under oath and then ask you a bunch of questions. They're going to be very similar to the things that you and Ms. Calloway talked about because of through this form. Make sure you answer all the questions truthfully. And if you've got any questions of your own about anything, let me know. If you and your lawyer need to speak privately, we can do that. Maybe I can answer the question, but it's important you let me know if something is throwing you off, okay?
Okay, thank you.
All right, we're ready to go.
Ms. Carpenter, can you please raise your right hand? Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true and correct legal name for the record.
Camille Monet Carpenter?
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
I'm 24 years old and I've completed high school and I've went to college.
Where'd you go to college?
Georgia Military?
Did you finish or you did some college?
No, sir. I did it while I was in high school. I did dual enrollment and I was like 2 classes off from getting my associates.
Okay.
Ms. Carpenter, do you understand that you've been charged with the following offenses: 1 count of terroristic threats and acts, and 1 count of possession of a firearm during commission of a felony?
Yes, ma'am.
And do you understand that you have the right to plead either guilty or not guilty to those charges?
Yes, ma'am.
Do you understand if you plead not guilty or remain silent and refuse to enter any plea, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances relating to the charges?
Yes.
Would you like any more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and any and all defects in the indictment for purposes of the plea?
I do.
Ms. Carpenter, do you remember being arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentences?
Yes.
Sorry. For each charge which you're pleading guilty to today?
Yes, ma'am.
Okay, so the range for possession of a firearm during commission of felony is 5 years consecutive. And terroristic threats, let's see.
Used to be 1 to 5, but it may have changed.
I have 1 to 5, but I have a question right next to it. I think it's 1 to 5.
I'll look it up. You
Okay.
guys keep going.
Great. Is that your understanding of the range? Is that what your attorney advised you of as well?
Yes, ma'am.
Okay. Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the state is moving to null pros the possession of a firearm during commission of a felony, and we're reducing the terroristic threats and acts to disorderly conduct and pursuant to OCGA 161139. The recommendation is 12 months probation, 40 hours of community service, an anger management course, no contact with the victim, and a stay away from the incident location. And the state has no objection to early termination after all conditions are met.
Okay.
Is that your understanding of the recommendation?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
And do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if there are multiple charges to which you're pleading guilty to today, the court has the right to run those consecutive?
Yes, ma'am.
Do you understand that if the court orders a sentence that differs from the plea, you have the right to withdraw your plea?
Yes, ma'am.
Are you currently on probation or parole anywhere?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a guilty plea today, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, and the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Counsel, is she utilizing first offender?
No.
Okay. Is it your decision to waive these rights that I just listed and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Ms. Carpenter, how do you plead to the reduced charge of disorderly conduct in indictment number 24 SC 0038882-01?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
And do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
You understand that for a misdemeanor charge, you only have 12 months from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends that the evidence would show that on June 29, 2024, Officer Peter was working an extra job at 186 Auburn Avenue. It's the Royal Peacock nightclub, is my understanding. The defendant engaged in a verbal dispute with the bouncer at the door regarding payment for entrance into the club. There was a verbal dispute between both parties. The bouncer made a statement that he would lay her down, whatever that means to that party. But that was the statement that he said.
That the bouncer said.
That the bouncer said, yes,
Okay.
Judge. And so that sparked a reciprocal threat from Ms. Carpenter, and she did flash her firearm that was on her waistband before walking away. The extra job officer asked her to leave. She did leave the premises, went down the street while still engaging in verbal dispute with the bouncer. And officers ran the firearm. The firearm wasn't stolen or anything like that. And at that time, Ms. Carpenter was arrested for the charges. All this occurred in Fulton County, Georgia. Spoke with the victim in this matter, and they have no objection to the resolution.
So Mr. Sumter is the bouncer / off-duty officer.
So Mr. Sumter is the bouncer. And then there was also an
Got it. And that's who would have taken Ms. Carpenter into custody.
Yes.
He would have seen what this exchange. So Sumter's a private citizen / employee of the Royal Peacock.
Yes, Judge.
Got it. But the beef was between Sumter and Carpenter. Just not only a poor choice to flash the gun, but it was in front of an off-duty officer.
Yes, Judge.
Okay. All right. Got it. Thank you. Good morning, Ms. Jackson.
Ms. Carpenter.
I'm actually talking to someone online. I know who you guys are. So it so often throws people, but I'll look at you if I'm talking to you. Good morning, Ms. Jackson.
Good morning, Your Honor.
Do you have any criminal history information on Ms. Carpenter?
Ms. Carpenter does not have any prior arrests on file, Your Honor.
Got it. Thank you so much.
Yes, sir.
Now, Ms. Calloway, your turn. What do you want to tell me about this situation and your client?
Yes, Your Honor, this situation was very unfortunate. It was a reciprocal argument between two parties in which my client perceived the statement from the off-duty officer as a threat. Unfortunately, there was other officers around that heard it, but most of the officers on scene were on her side. A lot of them don't even believe that she should have gotten arrested. We got that on body cam, sent it over to the state. We fought really hard for dismissal in this case, but ended up coming to an agreement, which we think is a good resolution all around. And we're asking the court to accept the recommendation. Ms. Carpenter is 24 years old. She's a resident of Georgia. Her parents are here. They are both real estate. They have a real estate firm here in Georgia. She has completed all of the classes in order to get her real estate license, and she is now studying for the test. In the meantime, she's gainfully employed as a server. She's also pursuing an acting career. She's been featured on a prominent show with a very prominent comedian. She was, as the court heard, she did some college in Georgia military as a dual enrollment student, graduated from Fayette High School as the class president. She was a 4-year Letterman varsity there, and just an all-around good kid, never been arrested before at all. And this situation, again, she felt like she had been threatened and kind of responded in a poor manner, but she's here today to accept responsibility and to put this behind her so that she can continue on with her career.
Got it. Okay. Ms. Carpenter, anything you want to add?
No, sir.
Okay. I'm curious why you have a gun going. One, did you think you could bring a gun into the Royal Peacock?
Well, they already let me in the club.
Okay.
Yeah, I already got in the club with my gun. And so when I decided to walk out and go get my coworker, they decided to tell me it was closed. So that's when I was like, me and him got into an argument. And I just called him top flight security. I was like, you just let me in the club with my gun, you know? I didn't pull it out my
Is it
waistband.
that kind of club where you felt you needed a gun, or that was a fashion statement, or you
No, sir.
normally carry a gun?
Sir, everyone in my household has firearms. We all have firearms. My brother got shot in the back and he lost his kidney and his gallbladder. So after that, we all went to training, firearm training. We're always in a gun range. We just, like to be prepared. But at that time, I just had the wrong judgment. I made the wrong judgment.
Okay. I think that's a safe assessment, that when you're in a scenario like that, the bouncer's always right.
Yeah.
And the more you can do to de-escalate it, probably the better. But that's why I think this sentence makes sense. Anger management, stay away from the Royal Peacock, stay away from Mr. Sumter. I think that makes sense. It also sounds like you have moved on in a real healthy direction. would you be working with your parents in real estate, or you'd be independent of their business?
I would be under my mother. She's a broker.
Okay, great. And what is the prominent show with a prominent comedian that you were on?
Could have been Love by Drewski.
All right. Well, good. And where is it? You are server means like waitress kind of thing?
Sir, yes, sir. Yes,
Where is that?
It's Frida's Mexican Bar and Grill in Fayette County.
Okay. Do you live in Fayette County?
No, sir, my parents do.
Okay. All right.
And Your Honor, we would also like to add that she's already completed the anger management course. And so we would ask the court to terminate probation once she's completed the community service. That's the only other condition.
Okay. So let me walk through what I need to walk through. Ms. Carpenter, I find there's a factual basis for your plea to disorderly conduct. It sounds like there was definitely disorderly conduct, and maybe Mr. Sumter could have been arrested for that as well. And that's where we're leaving it, is that that was a disorderly moment. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this. You're not enthusiastic about it, and I get that, but it's your choice to be entering this plea. And knowing means that you have understood all the things we talked about. Do you agree with both those things?
Yes, sir.
Okay. You signed a plea of guilty form where you initialed a whole bunch of things and your lawyer signed it. But it looks like, I'm going to date it for you because there's no date on it. But is this your signature?
Yes, sir.
Okay. And today is the 13th of March. Do you authorize my staff, Ms. Carpenter, to sign the indictment indicating your guilty plea to the one misdemeanor?
Yes, sir.
All right, Ms. Calloway, can we sign for you?
Yes, Your Honor.
Ms. Dilligard?
Yes, Judge.
All right, we'll do that. So, Ms. Carpenter, I will sentence you on count one, which has been reduced to a misdemeanor, to 12 months of probation with the following 4 special conditions. 1, 40 hours of community service. 2, complete an anger management course. It sounds like you've already done that. You just bring proof of completion to probation, and you've checked that box off.
Yes, sir.
3, no contact with Mr. Sumter. Sounds like he's a stranger to you, but he may still work at the Royal Peacock. And that's why number 4, for the duration of these 12 months, you will be staying away from the Royal Peacock. Find another nightclub. That's not the one for you. I will suspend your probation after you have completed the community service. I'm not going to terminate it, and it may seem like a semantic difference, but it's an important one. That means still for the whole 12 months, you got to stay away from the Royal Peacock and leave Mr. Sumter alone. I don't think you're going to be seeking him out anyway, but it's a good buffer to have in there. This is less than a year ago when this went down, and you may feel a certain way about it and that place, and we'll just keep the peace for a while. So as soon as you complete your community service, then your probation is suspended, meaning you don't pay the supervision fees, you don't have to report, but that 12-month clock, it's going to run from today. That'll have to run all the way before, if you really are anxious to go back to the Royal Peacock, you can do that. By then, you're going to be an even more famous actress, and you're going to be selling houses and all that kind of stuff, and you'll be too tired to go to a nightclub. All right?
Yes, sir.
Any questions about any of that?
No, sir.
No? Ms. Calloway, anything else on behalf of your client?
No, Judge.
All right. Thank you for your work on the case. Ms. Dilligard, anything else? All right. To Ms. Calloway? Okay. Ms. Calloway, you are going to get an email from Ms. Nelson about misdemeanor probation. It's a private company. Their office is about a block from here. And Ms. Calloway will get it to Ms. Carpenter. Call or write or show up, whatever you need to do for that first time. It's generally telephonic reporting. You won't need to come see them, but you need to do what they say. They're going to want to get that proof of anger management and then talk to you about the community service. They may have ideas. You may have your own ideas. And as long as community service isn't like working for your mom, because that's not community service, it could be at a Boys and Girls Club, or you may be passionate about something. And as long as it's documented, you're not getting paid for it, then that typically qualifies as community service.
Okay.
So you can be creative about that. But the key thing is when Ms. Calloway tells you, here's how to plug in with misdemeanor probation, you jump on it, because they're going to know from us, hey, Camille Carpenter is a new probationer, and they'll wait for a little while. And if you don't appear virtually or in person, they send me a warrant, and gosh, we start this all over again.
Yes, sir.
Okay. All right. If there's nothing else, you all are free to go.
Thank you, Your Honor.
Ms. Gresham? Hey, Ms. Gresham, I'm gonna sign this and you'll be good to go. Thanks for your patience. Get that to Ms. Gresham. Thank you so much. Mr. Abate, good morning. No, not a problem. We had plenty of other stuff to do. Update you. Mr. Poole appeared virtually. Mr. Miller appeared in person. They were a little late too, but I told them they were free to go and that assuming you were working out some of your other stuff, we wouldn't get to this on the 24th. Okay. Ms. Wood told me about Dandridge, that she's still talking with Dandridge and you and is hopeful. And then you have a bond hearing with Ms. Cabrera. I don't know where she's right there, on the Williams. That's the third defendant in the shooting on the cut on the way to the Amazon warehouse. I think that is it for and Brandon Baker, I explained we wouldn't reach.
I spoke to him, so he does want to come out so that you can explain to him.
Okay.
what's happening. But
So-
he's good.
Okay. Why don't we we'll do, in just a moment, we'll do that. Miss Singleton had to step away, so we can't do Mender.
Just let her know when to come back. She texted me and asked me to.
Tell her to come back,
Okay.
please. So we'll bring Mr. Baker out. Mender is Ms. Dilligard, but why don't we do the Williams bond hearing? Because then Ms. Dilligard can talk to some of the people she needs to. So I'll talk to Baker, then we'll bring Williams out, and then we can do Mender. Okay?
Judge, you remind me what this Williams per se?
Well, let me look. Amori. You bet. I haven't forgotten.
Yes, Your Honor, I just want to make you aware, I'm on call for Clayton County, I'm a pro tem, in juvenile court, so I had to step out to do some, TPO.
Okay, so we need to get you out of here.
I'm not rushing the court ever. but
No.
I
I don't feel rushed. I feel informed that you got stuff going on.
Yes,
So let me take care of those two things with Ms. Cabrera, and then we can talk. I want to give Ms. Dilligard a chance to circulate with some of the lawyers here. Okay.
Talking to Marilyn about your crazy. She's coming. Oh, man.
Hey, Mr. Baker. Just wanted to explain what's going on and field any questions you might have. You are indicted with Mr. Pierce in a murder case. And currently, you guys are unsevered co-defendants. So side by side, charged with the same things. I mean, there may be one count that's different. But the serious stuff, you are co-defendants. Generally, the goal is to try co-defendants together. Mr. Pierce's case slowed down a little bit because we had to work through representation for him. You've had the same lawyer throughout and you're comfortable with your lawyer. Mr. Pierce wants to represent himself, but that meant that he and I had to have a pretty long conversation here in court. He had a whole lot he wanted to share with me about his worldview, but we got through that and he is now representing himself. Now that we've sorted that out, he just needs to see the discovery and then we can get your and his case back on a trial calendar so that the two of you can be tried together. That is how it ought to be unless there's a legal reason to sever you. And the classic reason is, I don't think it applies in this case, would be, I'm going to pick Mr. Pierce. If Mr. Pierce had given a confession and he said, yeah, I was there with Baker and Baker did this and that, you guys can't be tried together because he needs to be called to the stand to talk about the confession he gave, and you'd be entitled to cross-examine him about that. But you can never compel a defendant in his own trial to take the stand. So when it's your turn to go to trial, no one can make you testify. The state may love to ask you some questions, but you can say, I'm not testifying, and that's no one else's business. So unless and until I sever the two, I'm letting Mr. Pierce catch up, talking about probably the next trial calendar, the one just after that, and we're good to go. But I wanted to explain that as well. I'm confident that that was explained to you. But if you want to offer any pushback on that, or hey, I got questions about it, now's the time. Okay. You and Mr. Pierce aren't anywhere near each other in the jail, is that right? That's too close. All right. You're not worried about it? I can get him moved. Okay. All right, but you said 7 South?
Yeah, both of us on the 10th floor.
Okay. 200. Okay, that's good to know. I'll look into maybe having him be somewhere else just to keep it cleaner. I'm not worried about you doing anything, but I just want to make sure people aren't bumping into each other when they don't need to bump into each other. All right? Anything else? Are you here for Mr. Baker? Walk this way just a little bit so you can see someone's here, or you see who's here for you. No.
She had another plot to look at.
Oh, okay.
Sorry.
All right.
I love you.
All right. No, we're good. We're good. I told her to, all right. Mr. Baker, we'll see you soon, okay? All right. Thank you, Ms. Cabrera.
Thank you.
You ready, Williams?
Me? Oh.
No, we're gonna do a bond hearing.
Which Williams, John?
Maury Williams. Yeah. Ms. Wood, any updates on any of your cases?
Still working good.
All right, Ms. Rios, any updates?
Derek Rogers, we're good with the plea. I'm almost good with Edward Boseman. I'm gonna go back and talk to him one more time.
All right, we will do Rogers soon. We're gonna knock out bond hearings, and then I will talk with Ms. Duvernay and Ms. Dilligard about that case. So we did Carpenter, we'll do Rogers.
Just while we're kind of doing other things.
Hanging out?
Yeah, I'm gonna go back to my office. If, don't just let me know when we're gonna come back to Mr. Dandridge, because I have his other case.
You have the registry case.
Yes.
Got it. I'll let, if Ms. Wood, I think, is working hard on that, so Mr. Abate or Ms. Wood can let you know.
Yes, so I'll be back when we're ready to address that case.
Okay.
You want to write here, John?
Ms. Cabrera, do you want Mr. Williams up at the podium, or you guys want to be at the table? I'm fine either way.
Podium is fine, they don't have to most of it.
Okay, Mr. Williams, you'll come up and stand in front of that little TV screen, please.
Hang on to that.
Ms. Rivers, you ready?
There's nothing that you have to
All right, we're gonna get on the record in 25 SC 000816. Oops, wrong one. Strike that. 24 SC 006518. It's State versus, do you pronounce it Amori?
That's your name.
Yes, Your Honor.
Maury Williams. Mr. Williams, you are charged in this case with murder and armed robbery and some related counts. I've already had bond hearings for a couple people in the case, so I know a little bit about the allegations. And what I'm going to do right now is hear from Ms. Cabrera about why you should get a bond. or have your bond reduced. I don't remember what the status is. I'll look in just a minute, but clearly whatever it is, you can't make it because you're still in custody. So Ms. Cabrera will tell me her thoughts, and then I'm going to hear from Mr. Abadi. He's the prosecutor on your case. And then I'll let you know what I'm going to do with bond. All right?
All right.
Ms. Cabrera, when you're ready.
Yes, Judge. I don't recall, he was on the calendar, last week. I don't know if we did the arraignment.
I'm going to look right now. We'll take care of that as well. I think it was earlier this week that he was
Yeah, it
on the
was,
calendar.
yeah, it's like 2 days ago.
Yeah.
So yeah, John, we have him on the calendar before you for bond. As far as I know, he does not actually have a bond. He's been in custody, I believe, since October of 2024. He's 18 years old. He's in the 12th grade. He was going to Frederick Douglass High School. He was accepted into a dual achievement enrollment program with Atlanta Area Tech. So through there, he would do computer engineering and coding. I believe his family is here, several of them. So he's well supported. He is native to Atlanta. He was living with his mother. As far as any of the victim or the alleged victim's families or anything like that, he doesn't have any need to live anywhere near them. He has a grandmother that lives in Lithonia. It would be just him and the grandmother in that location. So he could be quite a distance away from this incident location and anybody that would be related to this. As far as his co-defendants, there's absolutely no reason for him to keep any contact with the co-defendants. These were individuals that he's known of for maybe a year and a half or so. These are not lifelong friends or anything like that. So there's no connection that needs to be held there. Before he was arrested, he was working at Top Golf, which he did for probably about 2 years. He was employed at Top Golf at the time that he got arrested. So that was a job that he held, and he was there maybe 3 to 5 days a week. Him and his brother also have an LLC. And so under their LLC, there were, several ideas under that, but one of the main ideas was a clothing company that they were working for or were working to develop. So all that to say, the young man had quite a few things going for him at the time of his arrest. He is not without support. He is not without guidance, and he is not without some options as far as what can be done. If he were to be released on bond, I would ask that Your Honor consider putting him on an ankle monitor. I've spoken with his mother, and she's comfortable with managing the payments for an ankle monitor. That he be given, strict conditions to his probation. That he have a curfew. That he not be allowed to leave to do anything other than to report to court or attend school. I don't think that it's necessarily a requirement that he returns to work for right now. Perhaps we just focus on completing the 12th grade, completing the dual enrollment program, and reporting to court as required. Like I said, he was just on the calendar for arraignment 2 days ago, so this is a brand new case before Your Honor. And I think you may have already addressed this with co-defendants before, but I am asking that Your Honor give him a reasonable bond with the ankle monitor and whatever many conditions Your Honor thinks is appropriate to add to that.
Okay. Right. Mr. Williams, were you brought over here 2 days ago? You just didn't get to come out. Is that right?
Yes, sir.
Okay, got it. Not Ms. Cabrera's fault. She was stuck in court elsewhere. And we did do the arraignments and bond hearings for your co-defendants. So I met Mr. Owens and Mr. Palmer. I believe they're brothers.
They are, Your Honor.
And you know them, but are related to them. Is sort of how it shakes out. Is that correct?
Yes, Your Honor.
Okay, got it. Okay. So I'm going to hear from Mr. Abate.
I'm sorry, I'm going to cut you off. Not that it's necessarily appropriate for this time, but if Your Honor were interested, I have several letters from individuals, family, church, friends, etc., in regards to him. I know it's not necessarily appropriate for the purpose of the bond hearing, but I do have those.
Okay. Appreciate it. Mr. Williams, I've already heard a little bit about what the state thinks the allegations are in the case. And Mr. Abadi will correct me if I'm wrong, but what I've understood it to be is that this was supposedly a deal whereby Mr. Coffey was going to sell a gun and maybe you and he had made the arrangements. But it was, I'm going to get wrong which one it was, Owens or Palmer, who actually took Mr. Coffey's gun and shot Mr. Coffey with the gun that
Palmer.
It was Palmer? Okay. It wasn't Mr. Williams is the
Right.
point.
No,
that
it was
I've
not at
heard.
all.
Right.
Right.
But it was, my understanding was it was Mr. Williams who sort of arranged the situation. But I'm gonna let Mr. Abate share what he's gonna share. And then Ms. Cabrera, I'll come back to you to see if there's anything you want to add and we'll figure out what we're gonna do.
Perfect. Thank you, Judge.
Mr. Abate, when you're ready.
Good afternoon, Judge, or excuse me, good morning, Judge. I don't have any reason to dispute as Ms. Cabrera's recitation of Mr. Williams' ties to the community. What I will say is that the state's contention that the defendant, Mr. Williams, is a threat or danger to the people in the community, or the community and the people within it based on the facts and circumstances of this case. Your Honor, your memory was correct. Mr. Williams was the individual who set up the armed robbery disguised as a gun purchase with the victim in this case, Mr. Coffey. It's based on the facts and circumstances and the types of ballistic evidence that were found on scene. There is at least 3 people who shot weapons, but based on Mr. Palmer's own confession to members of his family and to an individual in the Fulton County Jail, he did claim that he shot Mr. Coffey in the chest and that he believed that it's his brother, Mr. Owens, who actually shot the surviving victim, Mr. Arnold, who was also shot in the chest, or excuse me, he was shot in the chest and Mr. Williams was shot in the head. I apologize. Excuse me, Mr. Coffey was shot in the head. It's all my name's confusing. But the contention based on the statements of Mr. Arnold, the surviving victim, is that all 3 individuals after Mr. Palmer shot Mr. Coffey all began to fire in a barrage of shots towards Mr. Arnold. And they took off based on Mr. Arnold's recollection of how the events occurred. Mr. Williams is the one who actually took the gun from Mr. Coffey, and that's when the shots then ensued. I don't have any reason to believe that he is a risk of intimidating witnesses, and what I can tell the court is I don't have any felony history. He is, at the time of this crime, was only 17, is my understanding. I had checked with Miss Hudson Singleton, who was checking to see if there's a criminal history on the juvenile side, but at this time, candidly, I don't have that information.
Okay. Ms. Singleton, anything you were able to get?
Yes, yes.
Okay. Let's check one more source. Ms. Jackson, I don't know that you got this calendar for today, but Mr. Williams was on a calendar a couple days ago. Did you have a chance to check his criminal history, or can I give you identifying information?
I have that information, Your Honor. He does not have any prior arrests on file.
Okay, got it. All right, Ms. Cabrera, anything you want to add?
Actually, no. Ms. Hudson Singleton, she covered what I would have added.
Okay, that there's not a juvenile
Right.
history either.
Right. So he has no history to speak of. I believe this is, well, not even I believe, I know. It's his first arrest.
Okay, it's pretty serious first arrest, Mr. Williams. Where were you living back when this incident occurred? So August of 2024. I don't need an address right away, but were you living with your mom, your uncle, on your own? Where were you staying?
My mom, with my mom.
And that's where you'd be going back if you got a bond?
No.
No.
So what I'm asking for is that he be allowed to live with his grandmother, which is in Lithonia, which takes him completely out of
Far,
Atlanta.
far away. I like
Period.
that. Okay. All right.
You know, if his mom is working, but if there's something that she needs to do because his grandmother works too. So if there's something that his mom needs to do or to change about her own work schedule to accommodate, making sure that there are eyes on him always, she's willing to do that.
Okay. I want to be clear. I'm not in any way concerned about mom. I just,
Right.
if home for Mr. Williams, when this set of allegations went down, was with mom, I think a different setting while he's on bond, at least
Right.
initially, makes sense.
Right.
It is great that there is this level of family support. All right, Mr. Williams, given your complete lack of criminal history, and any history with our juvenile courts, the situation you have academically, the work history you have, and the scope of the family support that you have, I will set a bond. My guess is this initial bond is going to be too high. I don't know, but the way I find out is if you are still in jail 30 days from now, that was not a realistic bond, and Ms. Cabrera will be able to petition me to lower that amount. But it's going to be a significant amount because these are real serious charges. And I need to be comfortable that it's an amount of money that if your family invests it to get you out, you're not going to mess up and disappear because they lose that money if that happens. Okay. So I'm going to set a bond, see which counts apply to you, all of them. I'll divide the number across, but I'm going to set a bond of $150,000. It's going to be through the sheriff's 10% program. You'll be subject to pretrial supervision, level 3. That's the highest level of supervision. You will have to have an ankle monitor put on. And it sounds like right now your family's in a position to pay for that. So it will be a privately paid for ankle monitor. You'll start out with a curfew of 7 p.m. to 7 a.m. That can be adjusted if you are able to document, I've got school or a job where there's a pay stub for it. Not, hey, I'm working for this guy named Mitch, but I'm working at Topgolf or whatever it is. And if your hours are later than 7 p.m., we can shift that curfew around. But for now, between the hours of 7 p.m. and 7 a.m., you are at your grandmother's house. Ms. Cabrera, you'll need to email that address to Ms. Nelson.
I'll get that to her today.
That I can include that in the bond order. While you are on bond, should you make that bond, no contact with either of the co-defendants. They're in custody, they don't have a bond, so contact shouldn't be particularly complicated, meaning having no contact, but don't call them, and no indirect contact. If they're getting calls from someone saying, hey, we were talking to Omari and he said this or that, that's going to be a problem for you, not for them. Okay. Mr. Abate, any other conditions you'd want to see on the bond?
Your Honor, I'm just glad we had this because it reminds me I need to get you what you requested as it relates to Palmer's statement.
Yes, you do. That might affect how we roll forward with all this. Anything else, Ms. Cabrera?
Nothing further, Your Honor.
So you'll get me that address, and do you have any questions, Mr. Williams, about this bond? Because the time to ask wouldn't be if you make the bond and then you violate your curfew and I revoke your bond. Oh, wait, I didn't know what you meant by curfew. Do you have any questions about anything that I've described?
No, Your Honor.
I do have one question, Your Honor, just so that the family knows about the establishing of the ankle monitor. Is there a certain company that they definitely need to go through?
Second Chance is what the vendor who's connected with the sheriff's office and the monitoring reports that we get. So
Okay.
I think you can connect the family with that, but you won't be able to leave the jail without the ankle monitor on you. They put them on there. They know how to do that. They do that all the time. So I just don't know how that connection is made, but it's knowable.
Okay.
Okay.
Ms. Cabrera, this may be a good opportunity going forward that he can think about cooperating with them.
I will see too.
Okay.
All right. That's all I got with Mr. Williams. Thank you.
All right, thanks, Judge. How soon did you want to do Mr. Mender?
Right now.
Okay, let's do it.
All right.
Don't leave. You can go in the hallway, just don't leave.
That was.
Yeah, that's his tribe, so I just don't want them to leave.
All right. We're going to get on the record now in State versus Quinard Mender. That's 25 SC 000816.
His mother may be virtual.
Okay. Is there anyone on the call? Currently, we still have one of Mr. Gill's relatives on. Welcome to stay on. There's no one else on the call. Anyone here for Mr. Mender? Nope. Okay. Mr. Mender is juvenile, and Ms. Cabrera, I'll let you get this on the record in a moment, but you conferred with him on Tuesday, and I believe he's waiving his presence because it was going to be hard to get him here, but we didn't want to delay the bond hearing all that much.
That's correct, Your Honor. I had this opportunity to speak with him 2 days ago. We talked about having the bond hearing, and he was comfortable with me moving forward without his presence, understanding that there may be a little difficulty trying to get him back here today.
Okay. So I will hear from you in a moment. I've already had the bond hearing for the two co-defendants, and as part of that process, I asked Ms. Dilligard to get me a copy of the MARTA video.
Yes.
And I've watched it.
Yes.
And I will tell you my distillation of it is that it's not an immunity situation for any of the defendants. I don't think this is a self-defense situation for any of the defendants. It's pretty darn close to a merely present situation for Mr. Mender.
Correct.
If you've had a chance to watch it. It
I
is
have.
a terrible video for the other two defendants. It's not a great video for any of the young men.
Right.
I'm just putting this out up front. Qualitatively, your client's involvement seems to be different from the guy who hands the gun to the guy who, for no apparent reason, after the situation is done, turns and shoots this guy in the leg.
Correct.
So, with that helpful upfront, what do you want to add? I don't know anything about Mr. Mender, so I do need to know.
So, Mr. Menders, he's 15 years old. He's in 8th grade at Woodland. He really should be in, I think, the 9th grade. But they were working on that part. He just kind of getting his footing in and getting comfortable. But he lives with his mother. His mother is, she is not currently employed at the time, so she can be with him. She can make sure that he is supervised the whole time. I would ask that he be placed on an ankle monitor and that Your Honor grant him a bond that is reasonable. He has an opportunity, I believe, to have school virtually. And so if that's possible and if that's okay with the court, I would ask for that. That he be allowed to attend school virtually, that he be given an ankle monitor. If there's a curfew given to him, a tight window. Just, you know, he's young, he's 15 years old, and he does not necessarily have to go to work someplace. So he doesn't need the same freedom that I was asking for the other gentleman. He was, I think these are friends that he had only a very short period of time. From my conversation with him, he's maybe known these boys a month or two. There's no reason for him to speak with them. He doesn't personally know the victim, no reason to contact the victim's family. And he's always been in Georgia, so he doesn't have somewhere else to go to. There's not a place outside of Georgia that he would otherwise travel to.
Any sense of who else lives in the household with
He has,
his mom?
He has 3 brothers. His brothers are 21, 18, and 17.
So he's the little one.
He's a little one.
Okay. All right. And what's your sense of what reasonable is for the Mender household if Ms. Mender's not working?
I mean, as low as humanly possible. I know that she's going to have a hard time making that payment, and she's going to have to talk to other people to make that happen. So as low as Your Honor can make that with as many bells and whistles on supervision as Your Honor deems appropriate. But I do know she is very limited on what it is she can afford to do.
Okay, got it. Good morning, Ms. Dilligard.
Morning, Judge. Judge, due to the seriousness of this offense, the state is inclined to ask for no bond. However, taking into account this defendant's role in the commission of this crime, also his lack of criminal history, as opposed to the other defendants in this matter, the state will leave bond in the court's discretion.
Okay. I think Ms. Singleton's behind you. She had sort of, there she is. She was here. Good morning. Can you tell me what you know about Mr. Mender's juvenile history? And then Ms. Cabrera referred to bells and whistles. And I know this would be a DJJ sponsored supervision, which means it comes with all sorts of conditions. And I'm loath to say, here are the conditions, because I always miss one and it's less impressive than what would happen naturally. So if you could tell me juvenile history and then what that bond would look like, not the dollar amount, but all the conditions.
Yes, Your Honor, he has no juvenile history.
Okay,
If he were granted a bond, the standard would be supervision by myself. Typically a 24-hour curfew, except for school, medical appointments, attorney visits and court. And there is typically, but it does not have to be, a statement that's usually on there that other permissions can be granted at my discretion.
Mhm.
And that typically is a situation where I always approve here, that's a standard, but anything outside of that is an earned type of situation. Which I explained to all the juveniles. So that's worded on the bond order. He would receive wraparound services through DJJ, which is in-home counseling. They also receive permission to be able to take in places to do their counseling sessions with him. He would receive an ankle monitor paid for by the Department of Juvenile Justice. Typically no weapons, no social media, and no contact with the 2 co-defendants that are on the case here, as well as I had requested for those 2, if Your Honor granted a bond, that no contact with the 3 co-defendants that were transferred to juvenile.
that's right, the 3 young men who, right,
And I have sent an email to Ms. Nelson with all the names and
Great.
everything. 2 of those 3 have been given a bond down there, so they're already out.
okay.
My understanding of it is, as Ms. Cabrera had stated, I believe, is that Mr. Mender did not know any of them. One of them he met through a relative, and
Correct.
I think Instagram met some of them.
He
Okay,
did say that he's known them, like I said, maybe a month or 2, but these are people that he didn't go to school with, that he doesn't live near, that he met via Instagram.
wow, okay. I'll make sure not to meet lots of people through Instagram.
Don't meet anybody on Instagram.
That didn't end well for him. Okay, well, like I said, watching the video helped clear up sort of why people went in different directions procedurally as well, because there were 3 young men who were physically present but weren't part of that little circle around the gentleman who got shot. And I guess those are the 3 who are still in juvenile court. So Ms. Cabrera, I will set a bond. And what I'd ask Ms. Singleton is if you could email to Ms. Nelson what you view as those standard conditions. I just don't, in particular, I want to have that safety valve provision that gives you the ability to create an exception to the curfew. So if you could just send to her what you'd like to see in a bond order every condition you mentioned needs to be there. The curfew, except for or as granted, wraparound services, no weapons, no social media. But I just don't want to omit something. I tried keeping up, but I think you've got a standard set of language that you prefer is in there that gives you both the most flexibility, but also the most number of tools to ensure that it's meaningful supervision and has some good guardrails in there. And Ms. Cabrera, what we'll need to do, sort of like with Mr. Williams, if it's been a month and, or maybe even less, because we're dealing with a 15-year-old, the family hasn't been able to make it, then just email me, Ms. Nelson and Ms. Dilligard to say it didn't work.
Okay.
I'm trying to strike the right balance. They are serious charges. And Mr. Mender wasn't uninvolved, but his role to me again is compared to gun purveyor and gun user. So sort of like you heard Mr. Abate say about Mr. Williams, Mr. Mender might want to avail himself of chatting with Ms. Dilligard with you there. But that's for you guys to sort out. I'm going to start out with a $20,000 bond and I'll spread it out across the counts.
Okay.
I mean, only 3, and he may not be charged with all of them, but we'll start at 20 through the sheriff's 10% program. So you can let the family know the money that they are able to generate, most of it will come back when the case is resolved, minus the fees. And then we can revisit it if we need to down the line.
All right.
Okay.
Thank you, Judge.
You bet. Thank you.
Was his mother able to? I can't
She
tell.
wasn't when we started the conversation. No,
Okay.
Unless she's named Jamal Gill,
No.
the only person on.
I'll call her and let her know.
Okay. And you had mentioned she was going to try to be here.
Yes.
I'm not taking that as a knock that she's
Yeah.
not interested in. Sometimes folks can't navigate the Zoom
Yeah, no, she made sure that she got the Zoom link information. It was like after 9 o'clock last night, but she made sure that she got it from me.
Okay.
So I will follow up with her.
Do you, Ms. Singleton, already have the address that I should put in for the curfew location, or do we need to get that from Ms. Cabrera?
I have it.
If you could put that in the email that you send, that would be great.
Yes.
Thank you.
Thank you.
All right. Did we cover all of
I
your?
had 3 things. We did all 3.
All right. Then thank you for being here.
Thank you, Judge.
And we'll see you around.
Yep, I'm gonna go in the hallway and talk to.
Oh, yes, you've got a big old posse
Yes.
for Mr. Williams. All right. Mr. Luemba, have you had a chance to talk with Ms. Ford and Ms. Dilligard, or?
I have talked to Ms. Dilligard. I haven't talked to Ms. Ford, but they haven't brought her up.
Right.
I have something important to relay when I do talk to her that I think gonna resolve this thing.
Good. Do we know if the females are in the building yet?
They're here, Your Honor, but due to the fact that we have few separates.
Yeah.
It's not myself down there.
Okay.
Here, so.
So tell me who if I
say
step
we
off, can
need
we
to
take
get,
a few people down so we can bring, I know that it's 2 females?
Yes, two.
Okay, Ford is the more urgent one, so if we've got space for one, and she won't need to stay up here a ton of time, but Mr. Luemba,
Briefly.
yeah, and she need to speak.
That's fine. Your Honor.
Okay, and I know like some of the folks I think I only talked to, Williams and Baker can
Yes.
go down now. I don't know if that opens up enough space.
The Rogers, you do Rogers, then that way we'll be able to get her up here.
Okay, well, I'm gonna get updates from everyone on that. We'll figure out what we can do. All right, Mr. Frazier's gone, so I guess that is looking like a trial in 2 weeks. Mr. Rouse, do we have an update on
I'm
that?
still working on that. Did you just see my text messages, Russ? I'm just waiting on documentation, so.
Okay, oh, right, Ms. Charles said what she said, we needed documentation. Okay,
Yes, and I've
Got it.
spoken to who I need to speak to, so we're just waiting on that email, Judge.
all right, I'll sit tight on that. Hanholt is not up yet. Dandridge, you're still working on.
Yes, and Ms. Primovic was here, she's gonna come back,
Good.
to speak with him, and also Mr. Williams, I'm gonna send him down if that's okay. John
Yeah,
Williams.
yeah, so both Williamses can go down,
Perfect.
Amori and Jai. Ms. Rios is not in here right now. Ms. Ford, we just talked about. Mr. Baker, I talked to. I got an email about Boseman. Nope, that was Rogers. I don't know what's happening with Boseman. We'll talk about Mr. Lett when I finish doing this second run through attendance. Mr. Holiday.
He's still here, Judge.
Yeah.
This is not going to resolve today. I can be ready on the 24th. I would ask if this one could roll to the April calendar simply because he has a new number and I wasn't able to speak to him between my most recent offer and today. So I do just need a little more time on this one.
Okay, let me think about that.
Okay.
He should stay here. I know he's probably sleepy because he got up early, but he's out. So I'll circle back on that. Rogers is a plea. And what about Mr. Brown?
That's gonna be a plea. I just need to go over it with him, Judge.
Got it. Okay. Then Ms. Duvernay, why don't you and Ms. Dilligard and do I have the right prosecutor on? I do. Let's go into the jury room and talk, and we'll figure out what we're gonna do.
Thank you, Your Honor. Excuse me, I think I'm going to take that day. Once I get the paperwork, I'll be able to send you over this possible.
Are you confident that the paperwork exists? Yeah, I don't mean to keep you here, but if this is it didn't really happen kind of thing, then the case doesn't go away. So I'm not doubting anyone. As long as you're available to come back, you don't need to be glued here. Okay, good.
Thank you, Ms. Charles. Okay. Okay. Thank you.
All right, let's Just head right over there.
Yes, Judge.
Morning. I like it. That's good.
Do you understand? Yeah, we'll get.
You wanna, we can't, I guess, do this. Rogers is the one thing.
Yeah.
So, tell me about that, why is she? I'm supposed to be in the coordinator. I did that. Yeah. Sorry.
So I thought you were, she get finished.
Adam, where does that go? Out in the back. I don't know where Lacey went. Y'all need to use your phone. I gotta step out, use your phone. Appreciate it. Oh, okay, that's so. My sister. Can I go? Yeah. Okay, thank you.
How does that the downward deviation for I believe it's not just ask for a downward deviation, like how is it?
So you guys just agreed to it?
Yeah.
For subsection E. And he's saying that, you know, we're stating the defense agreed.
Okay.
That downward deviation is appropriate to whatever y'all decide.
Okay.
So.
Are you about to take pleas in custody?
Yeah.
Oh, okay.
And then he can't come under it or above it.
He can't go
He
under.
can't go over or under. He has
Got
to
it.
accept it or not.
Okay.
Because of you.
I just came back.
I know, but you're about to take a plea.
Oh,
They're not-
well, judge is in the back, so I can't go right now. So if you need to talk to someone, I don't know, Heisenberg's saying he's gonna take a plea, but he's like really mad about it. So I'm like, I don't even know how this is gonna go, because he's gonna say he hates me.
Wait,
He said, because I talked to him and I was like, sir, like, what is your defense? I was like, I need to say something. And he's just like, I just like put his head down. He's like, I was having people, but everyone walked away. And I was like, okay. So I need to still go over stuff with him. Do you have a calendar? Are they your calendar? For what?
This lady is here. I don't have that calendar.
I don't have it. I don't think anyone for us is on that calendar. I think I did see something, but it was like no one for us, so I didn't print it.
I'm gonna call.
Holiday.
Well,
They don't understand. They just argue for the sake of arguing. I just shut down.
I noticed. I didn't see that you're using the thing, so I'm gonna call the litigation manager and I'm gonna go there because I didn't need to call, but I was.
Hold on one second, sir.
No, not yet. So we'll talk about it.
Pretty cool.
Do you know what? Did you leave?
She may be in the hallway.
Oh, excellent.
She was talking to that family, so a large number of people.
Oh, okay. Thank you.
Yeah, no problem. Hopefully she'll be there.
Thank you. All right, thank you so much.
Jasmine, so I think we might need to so this is 20 serve 7, the downward deviation, aggravated assault. How much we're doing for that? 7 years, 7 years possession of firearm during commission of felony. Since it has to be considered, can we do 5 years suspended? And then possession of firearm convicted with 7 years to serve.
Full call to order, May speak.
Mr. Abate, you are still, do we have any more of your stuff or you?
I'm just.
Oh, Dandridge, we're trying to work Dandridge out, right?
Working, I'm just gonna work.
Okay, great. We are stuck in terms of moving inmates around until we can deal with Mr. Rogers. Is
Okay,
that one that's worked out?
Yeah, we're ready. I sent an email.
You did, okay, then let's do Mr. Rogers, and then we can take a break, or I can stay in here if it's, well, I don't know if I should. It's just the two of you? Okay, I can't stay in here while they move everyone around, but then we can get Hanholt and,
You want to take Boseman too?
Ford, take
And
you.
where Boseman's the plea, we could also do him too. I think did I email about him?
I have an email from you about Rogers. I want to do Rogers and then we can get people up. Mr. Luemba, we don't have forever. Hopefully he's coming back. He needs to talk with Ms. Ford.
Yes.
And
Step up. Push.
a cool ringer though. So let's do Mr. Rogers and then we can take stock. I know we got a couple, we got Mr. Holliday sitting out there and we'll figure out what we're gonna do.
Oh, can he sit down? Oh, yeah.
Rogers?
Yeah, he doesn't have.
He's on crutches.
Sure. No, as long as that's all right with the deputies, I'm good with that. Hey, Mr. Rogers, we're gonna have you sit right there, please. Can you, Ms. Rios, rotate the camera a little bit so it gets Mr. Rogers? Thank you. I'll just get that up here. All right, Ms. Dilligard, you ready?
Yes, Judge.
This is 24 SC 004406, State versus Derek Rogers. Good morning, Mr. Rogers. Ms. Rios tells me you are ready to enter a plea in your case. Is that right? Okay. Ms. Dilligard is going to put you under oath in just a moment, ask you a bunch of questions. You need to answer those truthfully and completely. And please let me know if you've got any questions of your own, all right? And make sure you speak up when you're answering. Ms. Rivers needs to be able to hear you. I'm having trouble, so she may have trouble. When you're ready, Ms. Dilligard.
Mr. Rogers, can you please raise your right hand? Do you swear or affirm that any statements or testimony that you give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. You can lower your hand. Please state your true, correct, and legal name for the record.
What is your name?
Derek Rogers.
Mr. Rogers, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there any medication that you normally take that you have not taken today?
No,
How old are you and how far have you gone in school?
45, some college.
Mr. Rogers, do you understand that you've been charged with the following offenses? It's 1 count of kidnapping, a count of false imprisonment, hijacking a motor vehicle in the 1st degree, possession of a firearm during commission of a felony, and theft of services.
Yes,
Do you understand that you have the right to plead either guilty or not guilty to these charges?
yes,
Do you understand that if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
yes,
Have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances relating to these charges?
yes,
Would you like more time to discuss the case with your lawyer?
no,
Are you satisfied with your lawyer's services?
yes,
Counsel, do you waive formal reading of the indictment and any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Rogers, do you remember being arrested on these charges?
yes,
Has your attorney advised you of the minimum maximum sentence for each charge which you're pleading guilty to today?
yes,
Sorry, I'm just going to run through the ranges with you. For the false imprisonment, the range is 1 to 10. Sorry, I skipped the kidnapping. Kidnapping, the range is 10 to 20. For false imprisonment, it's 1 to 10. Hijacking a motor vehicle in the 1st degree is 10 to 20. Possession of firearm during the commission of certain felonies is 5 years consecutive. And for theft of services is 12 months.
Do you understand those are the ranges for those
yes,
crimes? Great.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is to null pros the kidnapping count 1, and to plead to the rest of the indictment, it's 10 years probation. We're going to reduce the hijacking of a motor vehicle to the 2nd degree,
Okay.
which has a range of 1 to 10.
Okay.
The conditions of probation is 110 hours of community service. No utilizing any rideshare services, i.e. Uber or Lyft, and no contact with the victim.
How'd you get 110?
Negotiations. We came off of something, so I added a little bit, Judge.
Okay.
Is that your understanding of the recommendation, Mr. Rogers?
can you speak that again?
Is that your understanding of the state's recommendation?
Yes,
You understand that the court is not required to accept the state's recommended sentence?
yes,
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
yes,
Do you understand that there are multiple charges which you are pleading guilty to today, that the court has the right to run those sentences consecutively?
yes,
Do you understand that the court decides to enter a sentence that differs, that you have the right to withdraw your plea of guilty?
yes,
Are you currently on probation or parole anywhere?
no,
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
yes,
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
yes,
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
yes,
Do you understand that you are not allowed to possess or use a firearm while on probation?
yes,
Are you a United States citizen?
yes,
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
yes,
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
yes,
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
yes,
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
no,
Is it your decision to enter a guilty plea because you are in fact guilty?
under the Alford law.
Okay. I think you had flagged that in email. This is a plea being tendered under North Carolina versus Alford?
Yes, Judge.
Okay, got it.
So are you pleading guilty because you have decided that it's in your best interest to do so?
Yes, it's my best interest.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Mr. Rogers, how do you plead to the charge of false imprisonment, hijacking a motor vehicle in the second degree, possession of a firearm during the commission of a felony, and theft of services in indictment number 24 SC 004406?
Guilty under the Alfred law.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you only have 4 years, and for a misdemeanor charge, you only have 12 months from today to file that petition?
Yes.
Judge, if this case were to proceed to trial, the state contends that the facts would show that on January 3rd of 2024, the victim in this case, Oscar Perez Salcedo, Salcedo, received a request from the Lyft application to pick up this defendant at the from the Martyr Manziel Road parking lot. He said that when the defendant approached the vehicle, he immediately told the victim to turn off the Lyft application while presenting a firearm, brandishing his firearm at that time, and told the victim to drive to Tupelo, Mississippi. They began driving and they made some stops in Alabama. They made a stop at a liquor store. They made a stop at a food mart. They made a stop where the defendant engaged in a drug transaction, and then they made a stop at the cigar lounge. It was at the cigar lounge where the victim was able to get away from the defendant, go back to his car, and flee. The defendant then came back to Atlanta the next day went to report the crime. He had to go to a few different locations. First, he went to Marta, and then they told him to go to Roswell. Then Roswell told him to go to Alpharetta. He also is not English speaking, and so he had some difficulty reporting the crime. So the crime initiated here in Fulton County, Georgia. I have met with this victim multiple times. He is comfortable with the resolution. He does not want this defendant to ever be able to do this again to someone, and hopes that he learns from this. He does want the court to know that at that time, he was very afraid for his life, and he's afraid and that's where the stipulation or the condition of not utilizing rideshare services comes into play. That was one that was requested from the victim as well. Judge, there were a few concerns in the case, and that's why we resolved it in this matter. There were multiple locations that the defendant took the victim prior to him actually fleeing, and so there were some questions regarding
why didn't you drive away when Mr. Rogers went in the liquor store or whatever?
And as you can see, this defendant has some physical impairments as well. And so that is the recommendation of the state. We ask the court to accept.
Okay. But importantly, you've been speaking with Mr. Salcedo. He's aware of this, and his main focus is leave me alone and leave other Lyft and Uber drivers alone.
Yes, Judge. And I will add that he, in our last meeting together, stated that he has not been able to go back to doing rideshare services because of the trauma that happened here.
All right. Thank you for sharing that. Ms. Jackson, do you have any criminal history information on Mr. Rogers?
Yes, Your Honor. He has 38 cycles. The last arrest was April the 6th, 2024 in Brookhaven, Georgia, for aggravated assault and possession of marijuana less than an ounce, and possession of Schedule I controlled substance, and possession of a firearm during commission of a felony. There was no disposition for that arrest. Also, he appears to have an outstanding hold out of Griffin, Georgia, where a failure to appear The date on that warrant was June the 21st, 2023. The underlying charge was not listed. He does have misdemeanor convictions and sentences. One in 2022 out of Cobb County for obstruction of an officer. One in 2021 out of Byron, Georgia, for driving while license suspended or revoked. He received a nolo contendere sentence in 2019 for theft by shoplifting. There was a conviction in 2019 for possession of marijuana less than an ounce. And there was an additional conviction in 2019 out of Dunwoody, Georgia, for theft by shoplifting. And there was a conviction in 2017 for 2 counts of simple battery. And he has a misdemeanor conviction in 2016 out of South Carolina for driving without a valid license and unlawful U-turn. Nothing in addition, Your Honor.
Thank you. Ms. Rios.
Yes, Your Honor. Mr. Rogers is 45 years old. He's currently receiving disability in 2019 was in a severe car crash, which took his leg. So he is currently receiving disability for that. He has 3 children, ages 21, 24, and 2 years old, and also grandchildren, ages 2, 4, and 9. He currently, when he gets released, he'll be living with his mother in Atlanta, Georgia. You know, like Ms. Dilligardi said, we had a lot of back and forth discussions because there were some issues with the case that to me did not make complete sense. He's maintaining his innocence. He has a total different version of what happened that day. But he does want to be out so he can be there for his family, and he doesn't lose his disability. He did attend college some college at Lincoln College of Technology. We are also asking for a behavioral incentive date. If he has nothing in of the 5 years on probation, if it can be terminated early.
What do you know about the DeKalb County aggravated assault case? I don't mean the facts behind it, but is that open? What's happening?
I am not sure.
It's still unindicted. Okay. Anything about the hold from Griffin?
I believe he said that was a traffic offense that he missed for traffic.
But you think there's still a hold for that?
Yes, there is. I'm pretty sure that's hold is still there.
Okay.
So he wouldn't be released. I've already explained that he wouldn't be released to the street.
Got it. Mr. Rogers, what is your version of events? How did this come to pass?
Well, I ordered a Lyft ride on the 3rd of January. And when I got
to go where? Like when you punched it in, like
I punched it in to go to Jasper, Alabama.
Oh, so this was a serious Lyft ride. You put it out there, I'm going to Alabama. It's a long ride.
Right, $240 they charged my card. When I got there, he seen how much the Lyft ride was gonna be. He said that he'd rather do it for cash. So he was trying to backdoor Lyft and make all the money himself. And so at some point during the trip, I don't know why he figured, he should leave me, but he threw my bags out the car. There was never a gun pointed at him, threatened him, or anything like that of that nature. So, I mean, I'm just really like tired of being in this jail. There's lots of stuff going on in there, and I think it's just the best route for me to go right now.
Where did you get thrown out of the car? I mean, I know he didn't throw you out. He threw your stuff out, so you had to get out. Where was that?
That was in Birmingham, Alabama.
So he got you to Alabama, but not to Jasper.
Not to Jasper.
How far is Jasper from Birmingham?
45 minutes.
How'd you get the rest? How'd you get the rest of the way?
Caught another Uber to the Greyhound bus station in Birmingham, and I Greyhound on to Tupelo.
But Tupelo and Jasper are different.
Right.
Why'd you go to Tupelo instead of Jasper?
I mean, that was the place that I was gonna go, but I only had a limited amount of money on my card, so I had to go that far on Lyft.
Got it. You figured, hey, I can make it to Jasper. They're gonna hit me for $240. That'll get me to Jasper. That's as close as I can get, and then you were gonna figure out a plan from there.
Right.
What's in Tupelo?
For Tupelo, I got family there, you know, all throughout Northeast Mississippi. So I was born in Monroe County.
Okay.
I'm just a Mississippi native.
Got it. But you'll be staying in Georgia.
Yes.
All right. Anything you want to add?
I wish this would go away. I wish I didn't have to commit to this 10-year probation, but like I said, I feel like this is the best thing that I should do right now. And so I'm going ahead with these pleas under the Alfred law.
Okay. You understand an Alford plea is when a defendant says, I don't agree with everything the state says. It sounds like you agree with some of it. Yeah, I rode in the car with this guy, but you've helped me understand where the stories diverge. But you're also saying it's in my best interest, meaning Mr. Rogers' best interest, just to wrap this up. I know I could go to trial. I don't want to run the risk. Mr. Salcedo comes in here. They believe him. They don't believe me. I got this criminal history, and the jury may find me guilty. And dang, I'm looking at 10 years to serve on the kidnapping. And so you've decided, after consulting with Ms. Rios and others, that it's in your best interest to go forward with the plea that Ms. Rios has been able to negotiate for you.
Yes, sir.
Okay. All right. I'll accept it as an offered plea. I find there is a factual basis for your plea and that your plea is knowing and voluntary. You clearly understand what we're doing. And I do think it's voluntary. You told me you're not thrilled about it, but this is actually how you want to work it out. You don't want to wait another month for a trial or this or that. You want to resolve it this way. I'm sentencing you pursuant to the Probation Options Management Act, which means that while you are on probation, which will be for a while, if you have a minor violation, you and probation work through that. You don't have to come see me. If you are arrested again for anything, that comes back to me. Any arrest, I'll be dealing with whatever consequences there should be. Do you have a weapons carry license?
No.
All right. Ms. Dilligard, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Ms. Rios?
Yes, sir.
Mr. Rogers, is it okay if we sign your name to the Alford plea on the indictment?
Yes.
We'll do that. I am going to sentence you on count 1 to nothing because that's been dismissed. Count 2, I'm sentencing you to 5 years to serve 9 months with the balance probated. Count 3 is 5 years to serve 9 months with the balance probated. That's running concurrently with count 2. Count 4 is 5 years consecutive to count 2. That is probated. And the final count is 9 months to serve. That runs concurrently with count 2. You'll get credit for the time you have served. You'll be on probation for 9 years and 3 months. Special condition of probation number 1, no contact with Mr. Salcedo. I know he's a stranger to you, but he's findable. Don't find him. No ride shares for you. I know that's complicated. It sounds like you're not doing a lot of driving yourself, but while you are on probation, no Lyft, no Uber. You get a ride with Fred or Jane or Marta, but no ride share. And you'll need to complete 110 hours of community service. I encourage you to find a place where that works for you. You just raised your hand. Yeah.
How do you do the community service in my condition?
So a lot of people, when they think community service, that's walking along the highway and picking up trash. And that's what it is if you aren't real engaged in the process. I don't know your family connections or friends or whatnot, but you could work in a soup kitchen where you're serving food or you're doing this or that. As long as it's volunteer work, you're not getting paid and you're not volunteering for a car detail shop where basically you're helping a buddy make money, but it is actually volunteer work and it's documented. So the folks who run the soup kitchen at a church or whatnot, they're able to sign a piece of paper that says, hey, Mr. Rogers is here for 5 hours today. That's community service. And probation will roll with that. You need to talk to your probation officer, but he or she will say, one, I got 10 other ideas, because they'll see you and say, no, what you can't be doing is climbing up in trees and getting trash out of trees. That's not going to happen. But there are lots of ways that you can do community service that are consistent with your disability. So work with your probation officer. But we're gonna get back together if it's been 6 months and you've done 0 hours of community service. In fact, I'm gonna require that you have done at least 20 of those community service hours within the first 4 months of your probation to show me that you're moving along with that. Your primary source of income is government benefits. I'm gonna waive your probation supervision fees then. I will set a behavioral incentive date of March 14th, 2030. So if you've done everything and not been a headache for probation, we can wrap up probation a little early. You're gonna be an old man by then, you'll be 50. And hopefully you're done with whatever kinds of things you were doing in this case, whatever got you in trouble in Griffin. And I'm gonna remind you, you still have this open case in DeKalb. That's not gonna affect your probation or anything, but you're gonna need, because your probation is starting after that incident. But you're gonna need to deal with that. Don't miss court for that. Missing court would be a reason for me to revoke your probation. All right? Home is going to be where for you? What county?
Fulton.
All right. Ms. Rios, anything else on behalf of Mr. Rogers? Ms. Dilligard?
Nothing further, Judge.
Ms. Simpson works with probation. She's going to give you reporting instructions for probation. All right?
Oh, Mr. Rogers, what you would need to do is make sure to report to the Atlanta office within 48 hours from your release. The Atlanta office is going to be 276 Memorial Drive. That's about 5 minutes from this building. When you report in, they will give you further instructions on in regards to community service.
Right. Just understood that I gotta go other places to deal with some things before.
Oh, that's right. I forgot about that. So it's 48 hours, you said, after release?
Yeah.
Right. So they'll know when you're released. You are next going to go to Griffin to deal with whatever's going on down there. You may be released from Griffin. We don't put a hold on you to say, no, you got to come back and be released from Fulton. And so whenever you are out there breathing fresh air again, not in an Uber and not in a Lyft, you need to get to the probation office here, a couple blocks from here, within 48 hours of being released. Okay? So yes, it is understood that you got some more time inside because you got to get down to Griffin so they can sort that out.
Okay.
All right? All right. Mr. Rogers, they can take downstairs now, which means we can bring up Ford and Hanholt. I need to step off the bench. It doesn't mean I can't talk with the lawyers so we can sort out getting Mr. Holliday out of here.
I have a couple of quick announcements, Judge.
Okay.
So Ms. Bernard, Tasha Bernard is actually.
She's here. Good. She was a special calendar here. All right. And Ms. Cabrera, you represent Ms. Bernard now?
Yes, I just got it, I don't know, in the last 24 hours, I think. So I do have her case. It's on a trial calendar.
Oh, I don't think so. I think it's a brand new case.
Yeah, it was like added on as an inquiry.
Where we just had, she must have at least one co-defendant. She has 2 co-defendants. And so we had, I don't know who represents the other people, but it's not you.
Okay.
So you're representing her. Let me pull her case up. And I forgot, I'm viewing this as an arraignment for Amori Williams.
Right.
So I need you to do the waiver of arraignment form for Amori Williams.
I thought it was 5. It should have been.
I'll look.
I'll do
It
one.
wasn't when we were talking this morning about bond.
I'll do it, because there was one from Mr. Mender that they thought wasn't filed, and it actually was.
Okay, I'll check in just a second. But let's look at Ms. Bernard. Yes, this is her arraignment date because her arraignment date was a couple weeks ago and we couldn't do it because she needed a lawyer. You are her lawyer now. Do you have good contact information for her?
Yes, and she has my information now too. She's gonna email me later. She gave us some other information, but yes.
Excellent. So Ms. Bernard, I'm sure we talked about it when you were here before. Tartan Court is a good address for you?
Yeah.
All right, so you'll get notice from the court in the mail, but more importantly, Ms. Cabrera will be sending you notice, texting you or whatever when you next need to come to court. And your schedule is already mapped out, your final plea date's in June, your trial's in July. If we get there, Ms. Cabrera is gonna get discovery from the prosecutor, meet with you, and this may be a case that's real easy to work out. I have no idea, but Ms. Cabrera is gonna help you think about that, okay? When she says you can go, you can go.
She can actually go.
All right.
So I had an opportunity to speak with her briefly, so she's able to go now.
All right.
All right. Thank you. That was perfectly timed. I didn't even realize she was on camera.
Yeah, that was great. I'm glad we connected that way. So I need to step off so they can, or are they moving people around? Hey, I'll grab that. Is he able to start moving people or?
Yes, once you get out, you're not able to take them down.
So he can't do that solo?
No.
Okay, so I need to step off, but what do you want to do before I do?
Kevin Rouse, did you see the email? Ms. Charles has submitted the order.
Let me look. This is an email from you or from Ms. Nelson?
She sent it to Ms. Nelson and I, so I was hoping it would get forwarded to you.
You sent me an email about Rouse?
Gotcha.
Pardon me? Okay, no, but I don't need to, if Ms. Charles has seen, she's good?
Yes.
So Rouse is Rouse here?
He's back in, yes, Judge.
All right, Mr. Rouse, your charges have been dismissed by the state. So I appreciate your perseverance. I don't know what the story was behind your case such that the state now dismissed, but you don't need to come back anymore, okay? All right, can he go?
He's good.
All right, take care. So that's a null pros?
Yes, Judge.
All right, so that's Rouse. Anything else?
Whenever you get back, we have you ready to go. Ethan Brown.
So Brown is a plea and then Holiday is not working out now. Do we need to talk about why it's not working out or it's just you can be ready
I can be
if
ready.
reached? Which of his cases would you be ready on? Or really the state gets to make that call?
I'll be ready on both.
Okay. All right. Do you need Mr. Holiday to stick around?
No, no.
Okay. All right, Ms. Dillard, anything you want to talk about concerning Mr. Holiday?
No, Judge. Your Honor said that the state would be able to elect which case to track. Okay.
Yep. Yep, and we'll talk about where that falls in the pecking order. All right, Mr. Holiday, you're good to go. And then we're saying Boseman is a plea?
Yes.
Okay, Boseman is a plea and
Murphy also might be a plea.
Brown is a plea. I'll go away so people can go down and Ms. Ford can come up because I know Mr. Luemba is stuck until he can talk to Ms. Ford, so they'll make that happen. I have a hard stop a little before noon. And then we're gonna be shut down for a few hours because there's a noon meeting over at Government Center. And I have to go testify in front of the Senate. But I will be back. And so things we don't tackle, I'll probably say just come back at 3 so you don't have to sit around and wait too much. I'm sorry, that's a big gap, but that's just how today played out. And another judge is covering presiding. So I'll step off. I'm gonna take care of these. I can come back out real quickly to hand them to you, even though they're still moving people around.
Thank you.
All right.
Thank you. All right.
Good. All right.
And it's just one.
Oh, it's just one.
Okay. Yes. I'll let you know.
Oh, I got you. Oh, hold on.
I know.
You bet.
It's gonna be a job at the airport.
Oh, phew.
Thank you so much.
You bet. Thanks for doing that kind of work.
Hey, how are you?
Hey, Laffy Taffy, is Dandridge gonna work out?
Miss
Oh,
Primovic.
Primovic is come, the hammer.
Yes.
Okay.
Yes. She had to go. She's in a different courtroom, but she'll be
Yeah, I
back.
saw her briefly. I'm like, wonder why I didn't connect the Dandridge dots. I can do that right there. That's perfect. If you hand me both those, I'm going, I gotta. Not go.
Of course. Help me open it.
Yes, let me go. I thought it would be okay because I use zipper.
Does you have scissors?
Yes.
All right.
I have a way to open it.
Would you like a laugh at that?
No, thank you. It's in tear right now?
Oh my god.
I was wondering, because those are terrible. I was like, what's happening?
Yes. It's not as well, but I'm right about it. Yes, but I don't think that the time that.
Boy, you can smell the lackey. I opened it like, whoo.
I don't think it's a matter of custody, it was just a matter of if that, there was no address, that was good. I think now I remember it, I don't tell you that I. That's the state. Got sufficient. Okay.
We'll stop.
$25 so 20. I need to take it. With the service notice removed.
Mm-hmm.
Takes.
Okay, so he'll be
care of-
parolable.
Yep,
Yeah.
take care of both of his cases.
Yes.
Yeah, so in the case and. Yeah,
Mhm.
so Adam even gave him options. Adam was like, you can take that. Or we can do it non-negotiated and ask for an enrollment, but Adam would leave the.
I need to go to the dentist.
The fuck? Is that a full fucking tube? Oh my god. Come here. How? Oh my god. Is that a toddler? Do you need me to? No. Okay. Wait, right here. Mr. Lord. You stuck here, I'm leaving.
Yeah, I gotta see Miss Ford before I.
She's good, and I didn't wanna not have the case, I just told her.
Yeah. If you don't have the copy, it's cool.
No, it's somebody else, but I'm tied to something else.
Oh,
They
okay,
haven't used it. Actually.
Yeah, I'm not there.
Yeah, and they were just like, cause I didn't wanna get it up. And
Yeah,
I was like, well, cause I was like, she can get it.
it's gonna be easy.
Yeah.
Yeah. I'm gonna talk to her, tell her what she need to do.
Yeah.
And call it, get this thing.
Yeah, it was gonna be easy. Anyway, let me go. They're looking for me in another room.
All right, for sure.
I was just like, I got trying to say out and then like, they want to get drafts on the orders real quick, so that they can have it inside.
Did you done?
I'm done being a state court.
Yeah.
Bad. Yeah, so I just went home down just to, that, picked it up, I had 46 messages. 46. In the time it took for me to talk to them in the back and be heard, I had 46 in 30 minutes.
Self-care, self-care.
Man, listen. Someone go find me a little bubble, a little geodome.
Yeah.
And just go live in that thing and
Yeah.
just watch deer.
All right, be good.
All right.
Yeah.
Have a good one. Thank you. You're so welcome.
No, I just have to talk to Ms. Ford.
Okay, got it. Thank you. Bench, and so, um, yeah, so just, one day we get back and get to the Thank you. Do you want to laugh at that? I'm scared. You're laughing at me. Not sure. It's all. Actually, I don't like chocolate. Is that weird? You don't like chocolate? I know. I envy you. So. What's it joke? Sounds like you're having a long day. Oh, okay.
Good, how are you?
I'm good. I don't know what happened to candy dishes, so.
At one point, I was told that they couldn't have them out.
And he has to take a break.
Because they
He's gonna
couldn't,
come back.
they don't wanna take a
No.
chance of.
Yeah, because they were like the last one, just substantially of it. So I'm like, you know, are you in here? We just had lots. Okay, we had those when we got in here. We had like a little like plot, like navy blue.
So I'm saying, I can bring them back.
Yeah, we used to have. Anyways, there used to be plastic books.
Cause you literally had the same idea, I was
130. Let me get some of this. 130.
back in.
She doesn't have it.
That's ridiculous.
Are you okay?
It's like, it feels weird a little bit, and so I'm trying to like call my dentist to see if I can broke. My whole crown came off.
What? Oh my god. I was gonna ask you for one.
I don't know. Would you like to?
No, I'm good.
I bite down that hard, and then I felt something, and I was like, and I
That
took it
happened
out,
to
and
me.
my fist was stuck on it.
No way.
It was like one of my can't remember what it was, but I was eating a piece of popcorn.
Yeah.
And all of a sudden it was like crack. And I'm like, what is
That's
Trying to see if they let.
That's one of those, like, I need to come in strong.
Yeah, because I'm not even sure if I can eat normally because it's gonna get in it because I don't have a crown covering it anymore. Just always.
This is actually Deputy Green's fault. He's the one that likes Tootsie Rolls. So I thought
This has never happened before. I eat candy a lot.
Yeah. Oh, yeah. Oh, that's good.
Can I come back too?
She right here. What's her name? That's four. Yeah, type perfect.
Yeah.
let me know when they're done.
My mouth smells. No, because I feel like it smells weird.
Oh my god. How many people are back there? Should I tell Marilyn to come up?
There's two deputies. You mean deputies?
Oh, okay, yeah. She's been like waiting. Hold on.
Murphy, stay away from that. He's an probation. Stay away from that.
Has Murphy on probation? I think he already had his probation revocation in the different courtroom. Pretty sure we already did.
So that you don't.
No God.
Yeah, we have one in December. I had to have.
Oh, honey, baby.
I had to have asked Ms. Nelson to send me a copy of it because the officer that was here then she put in a case note, but there is no record of it. And so I was like, oh,
Looks like it'd be free.
should I chase this or what? Because it looks like a figment of imagination.
Yeah, because he definitely had it.
Yeah.
If it was a different courtroom.
Yeah. So, but yeah, that was already taken care of.
Okay.
But yes, he is still on board. Thanks for coming down.
Of course.
What are you gonna do about, what's the name? Dang?
Yeah, I was seeing, because I don't think he has a history.
It's like a very clear.
But okay.
Like very clear.
I get what you're saying. However, that man didn't pay him his money.
But you don't get to put a gun on somebody.
I understand it, but it wasn't like a stranger armed robbery.
Your reason.
It's not like it was strangers on, like, it was a boss who said he was shooting money. Yeah, he did not act appropriately at all, but he's young and he's stupid and he's like doing good. He's a model. Have you seen him? He looks like a model too. He's modeling. He's with a modeling agency. Can we just like, can we reduce to robbery and let him take first offender?
Yeah, I feel like I need a little bit.
I know, but just only because he's young and it wasn't a stranger. Like I see if you like got on someone in the middle of the road, but it was his boss who like was trying to scam him, like not trying to pay him for his hours. According to the boss, but his boss could have just been shady and was like, I don't feel like paying him his lower hours and lied about him being asleep. Because people do that, so you don't have to. What do you mean? So you don't have to pay?
And so the motion to suppress.
Because he was like questioned before, like.
So then he was Mirandized and then he said the same statement.
Yeah, but it's still like fruit of a poisonous tree. Like you're not supposed to do the ask questions, then Mirandize after. Two-part. I think the officers like this like a two-part thing that they did that wasn't lawful.
Okay, yeah, I asked people specifically about that.
Yeah, but it's like a statement, but still, like you weren't supposed to do like the way they did was trying to elicit the stuff and then did that. You can't clean it up after you already.
I think the only, and he made my honest abuse, like, like, and then there's one question that the officer asked that I considered incredibly, before Miranda was, how did you end up in the car? That was the question. Everything else, he was blurting out, and he was like, yep, that's right, yep, that's what I did, so, I mean, I'm gonna talk to them.
If we could do, because I already talked to my client, if we could do reduce to robbery, first offender, he'll take it on.
I gotta.
Is he done?
We can set up something for anytime after. Next week.
Oh.
I knew you liked it. I don't know what color you like though. There's more if you don't like this. Okay, you're welcome. Appreciate it. Of course.
Looking up the court reporter. All right. It'll be frustrating if we can't try Mr. Williams on the 24th. Just airing that out. Ms. Ford is up.
Already spoke with her.
You did, great.
We relayed everything, kind of got two options going.
Okay.
Which I think the co-defendant may be taking the plea today.
Mr. Murphy? Oh, well, that'll simplify things for Ms. Ford. Okay.
Very much so.
Yeah.
It's just that I have to run the Cobb County, and
You got to be there, and you just jumped on this case, and
right. But if that's the case, I would like Ms. Ford, because basically she should read everything, so either way it goes. If we can come back as early as possible next week to knock her out, that'll be fine. We don't have to wait till the 24th.
No, we won't. And what I'll do is work with your schedule and Ms. Dilligard's. It may be we do it at a lunchtime. I'm in a civil trial next week. So we'll figure out when we can get you here, and we can always add one defendant to some judge's transport order to get Ms. Ford over here. Is her resolution something that gets her out?
Yes.
Okay, so we're anxious to do that.
Yes.
All right. Thank you for connecting with her. And it sounds like that cannot be today because you got to go. Okay, go. But she knows that, and she can go back downstairs when they're moving people?
Yes.
Okay, got it. Thank you for doing that, and I'll make a note. And if Mr. Murphy doesn't plead, then it's a possibility.
Option A, which is still a get out scenario.
And someone has keyed me into that. It might be something that gets tried, Mr. Murphy's case, in front of Judge Emerson the week of March 31. But again, that we'll manage that if we get there. Okay? Thank you, sir. Ms. Rios isn't here, so why don't we, if we could get anyone on bond out of here.
Brown.
Mr. Brown, come on up.
Yeah.
Just stand right there.
Let me take a good one for you.
Yes.
Mr. Luemba.
Yes, sir.
Quick process question.
Yeah.
We have a defendant in a 4-defendant murder trial, where, there is a lawyer who maybe, all of them are indigent. Ms. Cabrera already has one of the defendants, and we've got public defender on one, and, Mr. Regis on one. And then when we briefly, the county had a C3 program where we had a little bit of funding during ORCA. And so we had a roster of lawyers, Ken Shepard, Brian Hobbs, a few others who were helping out with cases. This is one of those, but that lawyer may be rolling off the case, not doing Georgia cases anymore. And so this person would be unrepresented. Would we contact you, or there's a laser?
Contact me, CCGPDC.
Okay.
Because typically it has to come directly from them.
Okay.
And then, but if you contact me and say, or contact Joy Walker from GPDC.
Joy Walker.
Or DeAndre Berry and say,
Okay.
hey, can we get a conflict for this guy?
Okay.
CC me on it. They're gonna send it to me that day.
Okay.
And then I'll put somebody.
All right, so CCU, but get it to Joy Walker or
Or
Mr.
Mr. DeAndre Berry.
DeAndre Berry.
Just let them know you're anticipating the conflict, and
Great.
and they'll shoot it to me.
Okay, great. We're just trying to get that fourth lawyer
What's his
in
name?
place. I don't know which one of the four. I'll let you know. And you all can sort through this. There's a few moving parts, but it's one that it's very old now. Everyone's in jail. They've been in jail. It's been reset a bunch of times, and here we are. I'll get that email out soon.
Great.
Thank you.
Thank you.
All right. Sorry, Mr. Brown, to keep you standing right there. Ms. Dilligard, are you ready?
Yes, Judge.
This is position 22 on our trial calendar, State versus Ethan Brown, 22 SC 004450. And Mr. Brown, I am told that you are prepared to enter a plea in the case. Is that right?
Yes.
You understand that all we're doing today is resolving this one case. You have at least 2 other cases that are with me. I think they should be, and we'll deal with those on a different day.
Yes.
Okay, and it may be we talk about them today, but today's resolution is just to this case that ends in 450. You're charged with aggravated battery and aggravated assault. Understand?
Yes, sir.
Okay. Ms. Dilligard will put you under oath, and then you'll answer a bunch of questions, and I'll answer any questions you have, okay?
Yes, sir.
Ms. Dilligard?
Mr. Brown, please raise your right hand. Do you swear or affirm that this statement, any statements or testimony you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the record.
I'm Ethan Brown.
And Mr. Brown, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Are there any medications that you normally take that you have not taken today?
No.
How old are you and how far have you gone in school?
I'm 20. I graduated high school. And
I'm sorry, keep going.
I graduated high school and I'm currently working on a trade school, Atlanta Tech.
Where'd you go to high school?
Carver Early College.
Sorry, what?
Carver Early College.
And you're at Atlanta Area Tech now?
Oh, yes, sir.
Okay.
Do you understand that you have been charged with the following offenses? It's 1 count of aggravated battery and 1 count of aggravated assault.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
Do you understand that if you plead not guilty or remain silent and refuse to enter a state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances relating to the charges?
Yes.
Would you like more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and waive any and all defects in the indictment for purposes of the plea?
So waived.
Mr. Brown, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum maximum sentence for each charge which you're pleading guilty to today? So as charged in the indictment, he's charged with aggravated battery, which is 1 to 20, and he's charged with aggravated assault, 1 to 20. Okay, let's make sure.
Unless it's an elderly person or a police officer.
No. Judge, but we are reducing the aggravated battery to battery pursuant to OCG 16-5-23.1. The range for that charge is 1 to 12 months. And then we're reducing the aggravated assault to assault pursuant to 16-50-20A. And the range for that is 1 day to 12 months. Is that your understanding?
Yes.
Okay. You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence. Judge stated the reduction from aggravated battery to battery, the reduction from aggravated assault to assault for a total sentence 24 months probation, 40 hours of community service, and no contact with the victim, Anaya Kirkpatrick. Is that your understanding of the state's recommendation?
Yes.
You understand that the court is not required to accept the state's recommended sentence?
Yes.
You understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
And do you understand that if there are multiple charges to which you're pleading guilty to today, the court has the right to run those sentences consecutively?
Yes.
You understand that if the court decides to order a sentence that differs from the plea you were expecting, you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
I'm on misdemeanor probation.
Do you understand that if you're currently on probation or parole, your probation and parole may be revoked based on your entering of a guilty plea today?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial.
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
Mr. Brown, how do you plead to the reduced charge of battery and the reduced charge of assault and indictment number 24 SC 0044450?
I'm guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file that petition?
Yes.
Judge, if this case were to proceed to trial, the state contends that the evidence would show that on February 21st of 2022, this defendant punched the victim, Anaya Kirkpatrick, with a closed hand, knocking out her multiple teeth in her mouth. Judge, the victim in this case went to the incident location to fight another female. There was a fight that ensued between the victim and that female. The whole entire fight is captured on video, which was posted to social media later on. In the video, you can see the two females fighting pretty vigorously, and then this defendant steps in and punches the victim, who I believe the defendant was in some type of relationship, possibly with
the other fighter.
The other fighter, yes, Judge. There was also concerns that the victim came to the fight armed with a knife. And so that is some of the concerns that were presented to the state and went into the negotiations with defense counsel. Myself and my team have reached out to the victim on multiple occasions, but have not been able to reach her, unfortunately.
But you're aware of what went down through the video evidence that's out there?
Yes, Judge.
Okay.
I do want to just put on the record, as Judge already mentioned, that this defendant does have multiple other cases. He has 2 indicted entering autos, and then I believe 2 other entering autos that have not been indicted yet, but it's the intention of counsel to do a global on those cases once I can get them indicted.
Got it. Okay. Yeah, I've taken a peek at the 2 that are indicted. One of them is
lots of cars.
19 counts of entering auto with a ton of co-defendants. And the other one has co-defendants as well. Mr. Chavis pops up on both those. So we'll work through those. Those are incidents that are more recent than this. So how many unindicted cases? You said 2?
2.
Okay.
Similar charges.
Got it. All right. Ms. Jackson, do you have criminal history information on Mr. Brown?
He has 6 cycles. The last arrest was November the 7th, 2024 with the City of Atlanta Police Department for battery, family violence. He does appear to be on misdemeanor probation for battery, family violence. That case number is 24 CR 0000377 and the letter B for battery, family violence. That disposition date was May the 10th, 2024, and the term is for 12 months. He appeared to have 2 open cases pending in Fulton County. The first case is 25 SC 000419 for 5 counts of entering an automobile and theft by taking, and financial transaction card theft, and financial transaction card fraud. The second case is 25 SC 000891 for 19 counts of entering an automobile. Nothing in addition, Your Honor.
Thank you. Ms. Wood, it's a funky posture we're in, but this case is on a trial calendar and the others aren't. And so this is one that needs to be resolved.
Yes, Judge. So he is 20 years old. He's a high school graduate. He's a lifelong Atlanta resident. He has family here in the area. He is enrolled at Atlanta Technical, working towards a welding certificate. He's currently working with his uncle doing construction and remodeling work. Judge, Ms. Dilligard and I are still working on the other cases. I will let the court know we are looking at some sort of felony, hopefully global resolution. So that is why I feel comfortable putting this before the court. I'm just asking that you accept the state's recommendation in this case.
Okay. Mr. Brown, do you have any questions about anything anyone has discussed?
No, sir.
How many hours a week do you go to school?
It'd be for like 3 days a week, so probably about 12 hours, it'd be 4 hours each day, so 12 hours.
Okay. How many hours or days a week do you work with? Was it your uncle in construction?
My uncle, yeah.
Yeah. How many hours do you do that?
Probably about 30 hours an hour.
30?
Yeah, 30.
Okay. And what does it mean to do construction work? What are you doing?
We might remodel the house, or it could go to like yard work or help put up stuff, refrigerators and cabinets and stuff like that.
Okay. All right. You understand that what we're doing today, I've asked you before, but we're at the tail end of this process. We're only resolving this case involving the encounter you had with Ms. Kirkpatrick 3 years. It was an old case. It was 3 years ago. Some fight between Ms. Kirkpatrick and who was she fighting?
The mother of my child.
Oh, so you have a connection to what was the person at that time, the mother of your child, or you didn't have a kid yet?
No, I didn't have a kid yet. But we was together.
All right. But you guys were talking back then.
Yes.
Okay. And what's her last name?
London.
London? Okay. Is that the victim in this family violence battery you have?
Yes.
Okay. So Ms. Kirkpatrick showed up to fight Ms. London.
Yes, sir.
And did you just watch the whole time, or when you got there, you broke it up?
At first, I had heard a lot of girls outside my house, so I went out there and tried to like prevent the situation, told them like just leave, cause this is my house, I can't be right here, I don't even supposed to come this way. So I said just leave. So when I went back in the house, I guess Miss London, she went out the back door and went around to fight. So by the time I got back out there, the girl, she had pepper sprayed her. She pepper sprayed and was just beating on the ground, so I had to stop that.
Okay.
Yeah, stuff like that.
Got it. How many teeth did you knock out?
I really don't know, cause I was really cause if you had the video, I was running from her, so I was really just trying to get back to the house.
Okay. All right. Well, Mr. Brown, I find there's a factual basis for your plea to battery and assault, 2 misdemeanors, and that your plea is knowing and voluntary. Ms. Dilligard, can someone in my office sign the indictment on your behalf?
Yes, Judge.
Ms. Wood?
Yes, Judge.
Mr. Brown, is it okay if we electronically sign your name on the indictment?
Yes.
Okay. Do you have a weapons carry license?
No.
I don't think this will have an impact on the probation you're on already, because this incident, I know your plea is coming while you're on probation, but the incident was way before you got put on probation. So you're just going to have it's going to be with the same organization. You probably have the same officer if they have officers there, but it's going to run at the same time with that. So on count 1, which is battery now, I'm sentencing you to 12 months probation. Count 2, 12 months probation. I'll run those consecutively, so it's a total of 24 months probation. You'll need to complete 40 hours of community service. Have you ever heard of something called the Family Violence Intervention Program?
Yes.
Are you doing that now?
I'm almost done.
Okay.
For my last probation.
Good. Well, I'm gonna add that here. You don't have to do it again. It's just when you complete it, that certificate will check the box here, but I'm adding as a condition of your probation that you actually complete the Family Violence Intervention Program. Okay. And while you're on probation, which is for 2 years, 24 months, no contact with Ms. Kirkpatrick. She does her own thing. You need to stay away from her. All right. Are you allowed to have contact with Ms. London, or is that part of your probation?
Yeah, no contact with her.
So how do you see your kid?
It'd be like through a third party, like a family member.
Okay. So you've got a mechanism to see your kid that leaves Ms. London alone.
Yes, sir.
Okay. All right. I think that's it. Ms. Dilligard, anything else?
Nothing further, Judge.
Ms. Wood?
No, Your Honor, thank you.
All right, so Mr. Brown, you're done for today. You will be back here on your other cases. The case ending in 419, which is you've already done a waiver of arraignment, and we did arraignment. All right, so that's arraignment happened. I think your arraignment on the other one is coming up. And we'll move those cases together. And then there may be more cases that are catching up to you. I'm sure Ms. Wood's going to try to resolve them all together. All right?
Yes, sir.
You'll get information. You know how to contact misdemeanor probation. I don't know. You'll just sort of get plugged in with what you already have. Okay? All right. Thank you.
Thank you, Judge.
All right.
All right, you're free to go. Have a good one.
All right, in looking at the clock, I need to go in a minute, so let's line up what remains. Mr. Holliday is not a plea. Mr. Boseman will be a plea. Mr. Murphy may be a plea.
I think he's a week.
Okay. Ms. Hanholt, have you broken bread yet?
I have not been back there yet, Judge.
Bring her some Laffy Taffy.
Because I have missing tooth now.
Your tooth came
I
out?
have to go get this fixed, it messed up now.
I'm assuming that like wasn't a real tooth. It was a crown or something?
Yeah.
You didn't just tear like a human tooth out of your mouth with
Crown
that?
fell off,
Okay.
and I need to go to the dentist.
Okay, well, I would sue your trial partner for giving you Laffy Taffy. It sounds kind of self-inflicted, but what about Dandridge?
I'm going back there again.
Oh, Ms. Primovic, they haven't connected yet?
She's in a different room, but she's coming up, so we're gonna plug in
Okay,
while you're on break.
yes, so let's plan to be back together at 3. If I get back from the Capitol before then, we'll send out a APB to everyone. But if you say, look, I'm 20 minutes away, that's on me, not on you. Let's assume we can start back up at 3. We can take care of Boseman, maybe Murphy. Ford is going to go away, but if Murphy resolves things, we'll bring back Ford ASAP. See what's going on with Ms. Hanholt. Maybe we'll take care of Mr. Dandridge. And I think that's it. Are there other cases that I have omitted?
I'm bringing that a different attorney. I know it doesn't work.
Please leave Dandridge up here.
Okay, you took him back, he said he's not gonna talk. Okay.
That's fine. I'm going to end up talking to him in the end. Yeah, keep Mr. Dandridge up. So Mr. Abate, you're welcome to stay in here till 3 if you need to be away from us. Hey, congratulations on your promotion, by the way. You're functionally doing it anyway, but there you go. But I'll be back at 3, if not earlier.
Thank you.
You bet.
I'm sorry, I will. Do you, file that on here? Yeah. Do you? Call it. It's fine if you don't, but mine is walking away. I am upset about it, that's fine. I think this is okay. Yeah. Okay, that's fine.
I would say.
And-
A
lot.
Could you always?
Yes, yes. But we'll go back over that. We'll break that out.
Meter.
Okay.
You rescued him? He's not gone?
He's not.
Good. All right.
So you. Oh.
Excellent. Ms. Kinlaw, how are you? I'm okay. Tell me why you want to change your son's name? Daughter, I'm sorry. Your child's name. How about that? That's great.
Okay. Because my last two, we were supposed to get the other changed, but we did not end up proceeding. We never proceeded to change the name as well. So I do want both their names to be the same.
So it's just lining them up with the same names. Okay, sounds good. I've signed the paperwork. And good luck with all that. Deputy will give it to you and you can be on your way.
Thank you.
Thank you. Thanks. So we're gonna go down at noon for an hour, just a lunch break. And then we're back up at 1 for presiding. So staffing wise, we just need one person. Judge Kraus is covering the presiding, but people will come here. Don't direct them to Judge Kraus. Bring the paperwork to Ms. Niles. She'll run it down to Judge Kraus if it needs a signature. And then we'll come back up for a few more pleas. As soon as I get back, hopefully before 3, but we're aiming for 3. All right, so 1 o'clock, 1 hour lunch break. Ma'am, did you leave paperwork with someone? Wait, you have the Laffy Taffy.
I didn't know he was going.
Oh, okay. All right, I thought you took the Laffy Taffy. Okay. As long as you're all set.
Bring him back up.
We got it. We'll get him.
So they need to leave here.
No, he's not. We got it.
Oh, excuse me.
Before judge come back, everything will be situated.
Okay, let me start first. Is Mr. Hall here?
Yes, sir.
Hey, Mr. Hall, how you doing?
Got a blessing on I know, sir.
Hopefully there's a blessing on me as well. Two things about what you're trying to do. Maybe it's three things. One, it does look like those liens are not valid. Two, the proper party to remove those liens is not Curtis Hull. It would be Baltic Property LLC, AKA Weems, whatever that name is. So we'll need to figure out who that is. That more accurately, you'll need to figure out who that is. That person needs to be here. And then the third part is on me, and that's figuring out the mechanism by which we do it. It's an order from me, but I can't just issue an order in sort of free-floating order. It needs to be associated with the case. And so I have my staff talking with the clerk's office, find out whether it's a number that I can initiate or whether whoever Baltic Property Dexter Weems is may need to go to the clerk's office to say, I need to open a civil case seeking to remove a lien. So the relief is there, but the relief is available to the property owner. And that may be you, but that's not what the records say. The records say, you know better than I do. That's why you're here. So I'm happy to help you with that. But we need to get the proper property owner in the mix, or you prove to me that you are that LLC or a member with authority to do something with it. And then we're working on figuring out what the mechanism is. So I'm gonna have the deputy, you're not losing anything. I'm giving all this stuff back. I'm the presiding judge for the rest of the week. So if you guys sort out, you can come back here. If not, Judge Farmer, I think, is presiding. There's gonna be a judge every day, every week, that you can bring this stuff to, okay?
Yes, sir.
I appreciate your patience. I know you were here for a while, but you were presenting something novel and we wanted to make sure we got it right. Okay?
Thank you.
Good luck.
I appreciate it. All right. Yeah, I appreciate it.
You too. And now I have a bunch of, I think they weren't warrants I signed, but that doesn't matter. They're warrant returns.
Yes, sir.
You guys are collectively here for that, or you're just the bodyguard for that one? All right. All right. Let me just look at them for a sec.
Only one warrant was served.
Yeah, it looks like a bunch of them. What is it not served? Like what happens when they're not served?
Oh, I'm just returning it to let you know that they weren't, so that the courts know that they weren't served.
No, I understand, but does that mean like, I'm just trying to see like like you didn't go to the house and kick in the door, or it wasn't that kind of warrant?
Correct, sir, yes, correct, no contact was made.
Okay, you were looking for a body? Or like you were gonna search someone who was there?
So it was to search the location as well as the agent / licensee.
Oh, so if Mr. Red was there, you'd have the ability to search him?
To arrest him, yes, sir.
Or to arrest him?
Yes,
Okay,
sir.
at the Parlay Kitchen? And you just, for whatever reason, strategically, you guys didn't do that?
Correct.
Why?
Well, per the search warrant, before we were to execute, we conduct the undercover detail where we have UCs go in to purchase the alcohol.
Yeah.
After hours, which
Yeah.
is what the infraction was.
Sure.
And the business was actually closed.
Oh, they weren't operating after hours?
So that day, they weren't operating after hours. So
They knew you were coming? Okay.
Yeah.
All right, so these are similar to the ones that weren't executed, it just operationally, it didn't work out?
So yes, sir, one operationally didn't work out, and then I believe the second one had a minor error. So
Okay,
I just redid it and had another judge sign.
got it.
But I did document it downstairs, so I just wanted it on record that it was not served.
Okay, and then these millions of receipts were what you got from serving at the Bamboo?
Yes, sir, I want to report that.
Okay, and are these all after hours out, is that your unit, you're the vice squad?
Well, license and permit.
Okay, license and permits, okay. All right, do you swear or affirm that your returns of service are accurate and correct to the best of your belief and knowledge?
Yes, sir, I do.
And who are you?
I'm investigator Felix.
Okay, great. Were you the one to whom these warrants were all issued?
Yes, sir.
Then you're the right one to be here today. I will sign these. All right. Thanks for answering all my questions.
Of course.
Was it good stuff that you got from Bamboo? Like, is that gonna help make cases, or is like, dang, all I got is receipts?
Oh, no, so the receipts helped to prove that they were serving.
They were selling stuff
That
after
they were
hours.
selling alcohol outside of the permitted city hours.
So I don't ever see cases about these. It's not a felony to do that, or you're just taking away licenses, or what are you doing as a, how am I in trouble? If I'm Mr. Bamboo Lounge operator and I'm selling gin and whiskey at 3 a.m. with no license, what do you do to me?
So in this case, this business does have an alcohol license. However, they are selling the alcohol outside of the permitted hours per city ordinance. So I drafted up a due course package that goes through the license review board. And it's to say whether or not their license should be revoked or suspended, if they'll have a fine.
Got it. So it's more of a financial or economic penalty for these business as opposed to you're taking away handcuffs and locking them up.
Well, sometimes individuals are arrested. In this situation, 2 of the bartenders were arrested.
Why?
For selling the alcohol at the hours.
Okay. And that is a misdemeanor?
It's a
City ordinance, enough to lock them up.
Yes, sir.
All right.
It's under 10.
It's under a title I don't see. It's not Title 16. Yeah.
Yes, in the search warrant.
Okay. I believe you. It's just new and different, so I'm curious. All the Post-it notes are yours?
Yeah.
Okay, good. I'll leave them in there. I just wasn't sure if they were from my staff attorney or not. So not served, not executed. This was the one that was executed. So you need to sign all these. I'm gonna give these to the deputy. You sign in the 3 spots where it says affiant, that's you, Investigator Felix, and then you are all set.
Thank you so much.
All right, good luck. All right, we have a critical mass now. Ms. Dilligard is here. What do you all want to do first?
I would ask Lieutenant Murphy first, if he still wants to.
We left him alone too long to,
So let's just.
do you want to talk to him? Did he see, like, did you go back there and you had this big gap and that scared him?
Yeah.
Okay. You want him to come on out?
Yeah, let's just see.
Let's see where he is?
Yeah.
Okay, like a hockey player.
I said, let me get it again. People want to just go like, I'm like, Jesus.
You don't want to watch you and see.
Man. He's down, man.
You always get credit every time, Sarah, but you're not.
Ms. Rivers, you ready? Let me find us in the calendar. There he is. Mr. Murphy.
Yes, sir.
How are you?
I'm doing all right.
Probably not great. I know you're in a difficult situation, but we need to figure out if you're going forward with a plea. Ms. Rios shared with me that after a whole lot of negotiating and tugging the prosecutor in her direction, she convinced the prosecutor to recommend a sentence that goes below the mandatory minimum. If you went to trial and were found guilty, that's if, I don't know what would happen at trial, but I'm sure Ms. Rios has been telling you about the strengths and the weaknesses in the state's case.
Yes, sir.
But if you were found guilty at trial, the mandatory minimum for armed robbery is 10 years, goes up to 20. I actually can sentence you to life for armed robbery. I'm not saying that I would. I don't know what I'd do. I don't know much about you or the case. I know a little bit because we've had a few hearings in connection with the case. But my understanding is that Ms. Rios was able to negotiate with the state to get the state to, I think it was to come down to a recommendation of 7, but we'd find all that out in the course of a conversation about a plea. I need to know if that's the direction you want to go or if your preference is trial, because I've got 2 trial weeks lined up where we could try your case, the 24th or the 31st. And the one thing that's different, and I promise I'll hear from you, is of course, if you go to trial and you're found guilty, you're not in a position to say, well, now I want to do something different. Then we're just talking about sentencing. And I'm pretty confident that the state's offer of recommending to go below the 10 years to serve would not be what they'd be offering if you're found guilty at trial. But I just said a lot, and I need to know if you are interested in going forward with a plea, or if you want to exercise your right to trial, let a jury hear all about what the case is, and maybe some of the other things you've been involved in, and we go that way. What's your choice?
My choice is to take the plea, but I want to know, make sure if the plea gonna be run concurrent with my probation that I already have.
It's a great question. Generally, things run concurrent. I don't know. I'm going to need to learn a little bit more about what you mean by probation you already have.
I have 6 years left on papers, and I want to make sure that it's run concurrent with my time.
So you think you have 6 years left of probation? You're not
Yes, sir.
serving time somewhere else?
No, not serving time, probation for this county.
Got it. Ms. Simpson, do you have any information about any open probated cases for Mr. Murphy?
Yes, Judge, he's currently being supervised.
Okay, and how much time is left on that case?
6 years, 2 months, 13 days.
Okay, so I don't want to get ahead of things, but what I can tell you is if I follow the recommendation, all that time that you'll be serving, and you'll get credit for the time you already did serve, but that total time you'd serve all would count towards that probation time. Put it differently, the clocks will be running at the same time. So I'm making it up. Let's say you still have 6 years to serve in custody. Those same 6 years, your probation clock would be running as well. Now, you may have some probation from this case, but they're going to be running at the same time. Did that answer your question?
Yes, sir.
Okay.
And one more thing, sir. Can that be mandated that I get in a TC after I leave so I could be on my feet? Because I don't want the same problem I had and I get out with nothing and nowhere to go. And you understand what I'm saying? I want to be ready for society after I finish doing my time.
I understand your desire. I don't know what a TC is.
It's a
Halfway
house.
Oh, okay. Got it. Okay. I can recommend that.
Yes.
But all I'm able to do is recommend it. I don't get to tell the Department of Corrections
I
what
just
to
want
do.
you to recommend. I just need you to recommend.
Okay. So both those things seem like reasonable requests, having the sentences run concurrently and recommending that you go through a treatment center. I need to hear more about you and the case.
Yes, sir.
So I'm not saying no, but I can't promise you anything yet because we haven't gotten through the process.
Yes, sir.
And another question?
I served 2 years already on this case, and I was out on house arrest for 3 months. I just want my time that I served for this case.
So I'll look at that,
Yes, sir.
and the records will show if you have been in custody for these charges, you will get credit for that time. Even if you got out for a little while, you'll get credit. You're not going to get credit for that time when you were out.
Yes, sir.
But any day you were in jail as a result of your arrest for the armed robbery and aggravated assault, the gentleman who's the victim in this case, you'll get credit for that. So I'm taking it at your word. If you already did 2 years, you got 5 left.
Yes,
That's
sir.
2 plus 5. And so we'll look at those numbers while we're working through that.
Yes, sir.
All right.
I'm going with the police, sir.
Let's see what happens. Ms. Dilligard, when you're ready.
Mr. Murphy, can you please raise your right hand to the best of your ability? Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state your true, correct, and legal name for the record.
Titus Chris Lyle Murphy.
Mr. Murphy, are you at this time taking or under the influence of any medicine, drugs, or alcohol?
Yes, ma'am. I'm underneath my I take medicines.
Tell me what you take medicine for.
For schizophrenia.
Okay. One medicine or a bunch of medicine?
Just one medicine.
How often do you take it?
Twice a day.
Morning and night?
Yes, sir.
Did you get it last night?
Yes, sir.
Did you get it this morning?
Yes, sir.
Okay. And when you take it, does it knock you out? You're confused?
It don't have me confused and not understand what's going on. I understand everything that's going on.
Okay. And have you been getting that medicine as much as you've needed it while you've been in?
Yes, sir.
Okay.
Mr. Murphy, how old are you and how far have you gone in school?
26 years old, 8th grade.
And is English your native language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? It's 1 count of armed robbery, 1 count of aggravated assault, a count of possession of a firearm during commission of a felony, and possession of firearm by convicted felon.
Yes, ma'am.
And do you understand that you have the right to plead either guilty or not guilty to those charges?
Yes, ma'am.
Do you understand if you plead not guilty or remain silent and refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances relating to the charges?
Yes, ma'am.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and waive any and all defects in the indictment for purposes of the plea?
Yes.
Mr. Murphy, do you remember having been arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? The range for armed robbery is 10 to 20 or life. Aggravated assault is 1 to 20. Possession of firearm during commission of a felony is 5 years consecutive. And possession of firearm by convicted felon is 1 to 10.
Yes, ma'am.
Do you understand that today you are entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, we are recommending that the sentence for count 1 be 20 to 7 pursuant to OCGA 1710 6.1. And then for the possession of a firearm would be 5 consecutive suspended.
Okay.
Is that your understanding of the recommendation?
I'm sorry, I missed it. So you're, I already said it, but I was writing some other things down. You're dismissing the aggravated assault, or it merges?
It'll run concurrent. It would be 7 to serve.
7 to serve.
Yes, and then it would be 7 to serve for the by convicted felon.
Got it. And then it plus 5 for, but suspended for the other firearm charge.
Yes, Judge.
Okay, thank you.
Is that your understanding of the recommendation?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
And do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
You understand that there are multiple charges to which you're pleading guilty today, that the court also has the right to run those sentences consecutively.
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the plea you were expecting, you have the right to withdraw your plea of guilty?
Yes, ma'am.
You said you are. So do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea today?
Yes, ma'am.
You understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
You understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
You understand that if you fail to follow any of the special conditions, you'll be subject to revocation in that probation for the balance of your sentence?
Yes, ma'am.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial?
Yes, ma'am.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Underneath the alpha, I'm pleading guilty underneath,
Alfred.
Alfred.
Okay. Are you pleading guilty because you have decided that it's in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
Mr. Murphy, how do you plead to 1 count of armed robbery, aggravated assault, possession of a firearm during commission of a felony, possession of a firearm by convicted felon, and indictment number 24 SC 002846?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
You understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition.
Yes, ma'am.
You understand that for a felony charge, you only have 4 years from today to file a habeas corpus petition.
Yes, ma'am.
Judge, if this case were to proceed to trial, the state contends that the evidence would show that on May 23rd, the victim, Kenneth Clayton, arrived to the Travel Lodge Motel located at 2471 Old National Highway in College Park to meet with a female that he met online. Mr. Clayton knocked on room 142, and the co-defendant in this case, Ms. Ford, opened the door, letting him inside. The female advised Mr. Clayton that she needed to use the restroom. She walked into the restroom, and Mr. Murphy walked out of the restroom armed with a black handgun. He pointed the handgun at the victim's head and demanded that he hand over all of his belongings. The victim began to take his items from his person and hand it to the defendant, at which point the defendant then pointed the gun up to the ceiling. The victim tried to grab a hold of the handgun in an attempt to gain control of the firearm, and the firearm accidentally discharged at that moment, but no one was harmed or hit. The co-defendant, Ms. Ford, then walked up to the victim, punched him 2 times in the face before both of them left the room.
When you say both of them, who's the both of them?
My apologies, Judge. Both defendants in the case left the room. They went to a room next door, and that's where they waited until their Uber driver picked them up. Officers were able to gather the CCTV footage. They were able to get the plate of the Uber driver that picked them up. Were able to contact the driver, who confirmed that he picked up both of the defendants at the location. Officers were also able to speak with the attendant at the hotel. They were able to retrieve the documentation used to rent the room where the victim was robbed at. Documentation showed that Ms. Ford rented the room. They got a search warrant for the room, which also produced identifying information for both of the defendants in the room.
The room that they retreated to, or the room where the robbery happened?
Where the robbery happened.
Okay.
There was social security cards in there. There was driver DDS information in there, medication pills in there as well. The victim was able to identify both of the defendants in a photo lineup. Just making sure I didn't forget anything. Oh, and the items that were taken from the victim were also located in the room. It was some jewelry, both a necklace and I believe a bracelet as well.
Okay.
And all that occurred in Fulton County, Georgia. Judge, we have been working really hard to, we've spoken with the victim prior. He's been a little bit out of touch, but my team has been working really hard to try and get back in touch with him. They were actually able to get some good information for him, but I have not been able to speak with him prior to the taking of this plea today.
Got it. Okay. Thank you. Good afternoon, Ms. Jackson. How are you doing?
I'm great. How are you, Your Honor?
I'm all right. Good to see you again today. Can you share criminal history information on Mr. Murphy, please?
He has 6 cycles. The last arrest was May the 27th, 2016 in Fulton County for armed robbery. He does appear to be on probation in Fulton County. That case number is 16 SC 144097 for 2 counts of armed robbery. It was March the 14th, 2017, and the term is for 10 years. And nothing in addition, Your Honor.
Thank you.
Judge, may I add one more thing?
Of course.
I did want to notate that in this case, there was a 404B that was, as Judge probably is aware, granted in part, denied in part. There was a similar incident that occurred previous to that needed to be beefed up a little bit before being entered, but I just want to bring that to the court's attention as well.
Okay. Ms. Simpson, I'm looking at the case for which Mr. Murphy is on probation, and I see there was a revocation order just before Christmas of last year but something to do with an address, but then there's an older one. Really what I'm getting at is, has Mr. Murphy had a revocation in connection with these charges?
It doesn't appear to.
Okay, that's another way we can manage the probation piece for Mr. Murphy. Ms. Rios?
Yes, Your Honor. Mr. Murphy is 26 years old. He has 8 children. I think he was previously engaged. He is engaged. He was working as a graphic design for Dream Lab Entertainment. I just ask that you go along with the plea as negotiated with me and the state. We trying to work hard on a resolution that would be agreeable to everyone. I know his history, and we know he had, of course, had a different side of things of what happened that day. But I think he's willing to accept this plea and go forward with the case and accept that what his part was in this situation.
Okay, I don't want you to reveal a defense, although we're about to resolve the case. I'm trying to work through the offered nature of the plea, given what it sounds like the evidence would be. Mr. Murphy's stuff is in that hotel room. I don't know what Ms. Ford would have to say about it. I suspect it's not super helpful for Mr. Murphy. And so it isn't going to undo the plea, but it helps me understand what Mr. Murphy's basis is for entering an offered plea. Because sometimes it didn't go down quite, like the gun wasn't fired, or she had the gun, I didn't have the gun. But if it's, I don't know what you're talking about, I wasn't there, we didn't take this guy's stuff, then I'm curious why we're not going to trial.
It's just a different set of exactly what happened. He's not saying that he wasn't there. He's just saying that the altercation went down a little differently than what was in the police report.
Okay. And there's the added complication for Mr. Murphy that the jury might hear about other situations in which he was involved where they'd say, well, here we go again. Okay, got it. Mr. Murphy, do you have any questions about anything anyone said?
No, sir.
Anything you want to add?
Sir, I just want you to know that when I came out of prison and caught this case, sir, like I had nothing to lose, sir. But when I got out on my bond, like I found this beautiful wife and I got beautiful kids in my family now, and I really got a lot I want to live for, and I really just want to go on with my life and move forward with this.
Okay.
So I'm just asking for.
Well, I hope that passion for life and family and 8 kids.
Yes, sir.
8 kids, that's a lot of kids for a 26-year-old. I hope those are things that keep you motivated, because you are going to get out. And when you get out, it's not going to be easy. You're going to be behind. You have been in prison. It's hard to get a job, all that kind of stuff. But you've used up all your chances. If you get wrapped up in something like this again, there's not a prosecutor who's going to say, yeah, we'll go below 10 years. The prosecutor's going to be saying, let's recidivize this guy and let's see if we can get life, something like that. And I'm not saying that to threaten you or anything. I'd like to see things work out. I'd like those 8 kids to see their dad and your wonderful fiance to see you not dressed like that. But that's going to require you to navigate things a little differently when you get out. And that may mean hanging out with different people or who knows what. But this isn't something that the way things have been playing out for you aren't going to keep you in your kids' lives. I find there's a factual basis for your plea. I know it's an offered plea, but that doesn't mean that the state couldn't prove it up and a jury might find you guilty. And that's the big dice you'd be rolling if you went to trial. I also find that your plea is knowing and voluntary. Voluntary means that you've decided this is in your best interest, which is what you're telling me when you say an offered plea. No one's forcing you to enter this plea. And knowing means you've understood what we talked about. And you did a great job starting our conversation by asking a whole bunch of questions. And I feel like I answered them for you. I'm sentencing you pursuant to the Probation Options Management Act. That means that when you're out and on probation, if you have a problem on probation, if it's a small problem, you and probation will resolve that. But if it is a bigger problem, any kind of arrest, that kind of thing, comes back to me and we'll work through a solution. Ms. Dilligard, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Rios?
Yes, Your Honor.
Mr. Murphy, is it okay if we electronically sign your name to the indictment indicating your offered plea?
Yes, sir.
we'll do that. Do you have a weapons carry license?
No, sir.
My suggestion, Ms. Rios, if you want to waive Mr. Murphy's notice rights, is that I revoke the balance of his probation in the other case, but give him credit for the time he's already served. You've served almost 2.5 years. I did the math. It's 882 days in connection with these charges. There was 2 chunks of time, a real long chunk, then you got arrested again. But if you add all that up, that's a little less than 2.5 years. So you'll get credit for that on the sentence I'm about to impose. But my thought is we just revoke the balance of the probation in the 16 SC case based on this new conviction, and that'll close that out.
Yeah, he had 6 years left on it. Was
6 years and 2 months.
Yes.
But if he gets credit for the 2.4 years he's already served, all of which post-date his original sentence, then he'll have completed that by the time he's released in this case.
That makes sense to you?
Do you have a question about that, or you understand what I'm
I
saying?
understand what you're saying.
Okay, so I'll take care of that. You don't even need to worry about serving it because it'll just basically be this sentence. Because the prosecutor has agreed to invoke this, what we call 6.1E, which allows me to go below the 10-year mandatory minimum, I'll do that. I don't know what the deal was with your old case with these armed robberies, because it got reduced a whole bunch, but you did serve 5 years. Did you serve all 5 of the 5 years?
Sir.
Okay. But it was reduced to robbery. You sure you served all 5 years?
Yes, sir.
I mean, you'd know.
4 years and 11 months to be exact.
I'm gonna call that 5 years. Okay. But you can see, here's another one you got wrapped up in, and the number only went up, and that's what'll keep happening. As to count 1, I'm gonna sentence you to 15 years to serve 7 with the balance probated. Count 2 is 7 years to serve. Count 3 has to run consecutive to count 1, but I'm gonna probate that, and then count 4 will be 7 years to serve concurrent with count 1. So the total sentence is 20 years to serve 7 with the balance probated. You'll get credit for the 882 days. Special condition number 1 of your probation when you get out will be no contact with Mr. Clayton. Number 2 will be that you get your GED. My hope is you get that, you're gonna have some time to yourself. Get your GED while you're in custody. GDC offers that up. That way, when you get out, whether it's to a transitional center or whatever, you've already checked that box. When you're looking for a job, they'll say, well, do you have a diploma? I sure do. I got my GED. It's also a way to make it more likely that you'll go to a transitional center. If you spend your time in GDC getting in trouble, they don't move you to a transitional center. But if you're doing something like getting your GED or learning a trade and mostly staying out of trouble, then the Department of Corrections will be more interested in following my recommendation, which be that you be considered for a transitional center.
Yes, sir.
Okay. I think I covered everything. Did you have something else, Ms. Dilligari?
Yeah, Judge, I don't think I mentioned this, but to have no contact with his co-defendant.
Okay. Your fiance is not Ms. Ford.
No, sir.
Okay. You and Ms. Ford need to stay apart for basically the next 18 years. That's sort of what's left on your sentence with all that probation as well. She'll go her way, you go your way.
Yes, sir.
Are any of your 8 kids with Ms. Ford?
No, sir.
Okay. Then that should be pretty easy. She'll do her thing and you do your thing. Anything else, Ms. Dilligari? Ms. Rios?
There.
All right. Mr. Murphy, Ms. Simpson's going to give you reporting instructions, but they don't really mean anything right now. When you are released, you will need to report to probation. You'll get notice of that in a bunch of years as well. But anything you need to tell them?
Just to report within 48 hours, if you happen to come up for parole before you max out your time, then your officer at the facility will give your instructions.
Amen.
Lastly, in the case of 16 SC 144097, because of your new conviction, your new felony conviction, I'm going to revoke the balance of that probation, which is 6 years and about 2 months. And that'll close that case out. You will get credit for the time you have served in custody. Those dates are in Odyssey, but if you can't get them, Ms. Nelson can get them to you, Ms. Simpson, but he does get credit for those 882 days. All right? I think that takes care of everything for Mr. Murphy.
Yes, Your Honor, thank you.
You're welcome.
Yeah, Mr. Dandridge, is this weird for that?
Yep, just one sec.
Okay.
Thank you.
So Ms. Nix can sort of be the proxy for both cases?
I think so. I've been texting with her about
Okay. Is there something I can help with, or just let them know what the deal is? Or I don't know what the deal is, and I don't want to get in the middle of the negotiations, but I'm happy to emphasize the consequences of no deal. Do you assess the state's case in the murder case to be a compelling case, or you look forward to trying it because you'll notch another not guilty?
Judge, I would like for you to explain the consequences to Mr. Dandridge. This is one, we actually had an immunity motion last August in front of Judge Dempsey.
And it was denied?
Yes.
Did he deny it like on the spot, or he? Okay, all right.
Yes.
Judge, I'll also note that you might tell the defendant that on the registry case, the maximum penalty is 30 years. And so even if he is found not guilty of the murder, he can still be sent to prison for 30 years on the registry case.
Right, that one, however, is parolable. Okay,
But before he gets out of here, hold on.
Well, hold on one sec. We're not quite, almost ready for Mr. Dandridge.
Mr. Abadi has kindly given us options. So.
He's given what?
Options.
Okay.
So there's two options here. The first option is if we do a negotiated plea, the offer is a plea to manslaughter, and it'll wrap up Ms. Nix's case, and it's 25 served 20, and the recidivist notice will be pulled. Option two is a non-negotiated plea, and the recidivist notice would then stay in place. So whatever happens, he would have to do.
But it's a voluntary. Murder is off the table. And then option three is we go to trial and life without parole plus 30 years, plus 5 more. Oh no, it's not even a gun. How did this person die?
Hands, yes.
Okay.
In the, with the candlestick by Colonel Mustard.
In the conservatory?
Yes.
Okay, all right, thank you.
And he is an ANC recidivist, so it could not be parole.
That's right.
Right, if that went through.
I don't think that I've filed in the registry case, but I could.
It will carry over. All right, you want to knock on the door?
Yes.
Hey, Mr. Dandridge, come on up to the podium, please. Good afternoon.
Good afternoon. How you doing?
I'm all right. We haven't talked in a while, and I just wanted to get up to speed with where you are and make sure you understood what I understood the options were. And then you can let me know what the plan is. I have a couple trial calendars that I've placed your case on. One with me, Mr. Dandridge is on the Emerson calendar, right? So one with me that starts not Monday, but the Monday after. And then one with a colleague who's got a 2-week calendar, that 1 week runs at the same time, but then a week after. So I got space, I think, to try your case if that's where we're going. Ms. Wood has helped me better see what the state has offered to you if you're interested in something other than going to trial. And so I just want to share with you what I understand the choices are, make sure you understand them, and you can tell me, because you're in charge. I mean, it's my courtroom, but I don't decide for you how we're moving the case. So it's been explained to me that one offer made to you is so you have 2 cases, murder, which is life or life without parole, and your criminal history is such, and the state has filed a notice that if you were found guilty of murder, we should start with, and that's a big if, I don't know much about your case, but Ms. Wood does, and hopefully she's been telling you what she thinks about your case. If you're found guilty of murder, I would have to sentence you to life without parole. And that means what it says, you would die in prison. There's no compassionate release. You've been told probably, hey, you get considered for parole after 30 years for murder, if it's murder with the possibility of parole. But if you go to trial and you're found guilty, life without parole. The state has offered, as I hear it, two options short of going to trial. One is negotiated. Everyone agrees. I don't have to agree to it, but I'm going to follow along. I'll listen along with what people have to say. One is 25 to serve 20 and no recidivist. So you're eligible for parole, and that's voluntary manslaughter. And your sex offender registry case would be rolled into that. So the overall sentence would be 20 to serve, credit for all the time you've been in, plus 5 years suspended, and you'd be eligible for parole. If you want to,
I don't understand that part right there. Could you make that clear? The numbers you're talking to me?
Sure. So right now you're charged with murder. I'm gonna focus on the murder case. That's the more serious one. A lesser included offense of murder is voluntary manslaughter. The state has the authority, I don't, but the state has the authority to say, you know what, we're gonna reduce it to voluntary. And if Mr. Dandridge wants to plead to that, we'll reduce murder to voluntary. The sentencing range for voluntary manslaughter is 1 to 20. And what the state has said is that if you agree to plead so that the victim's family doesn't have to go through the trial, et cetera, they will reduce murder to voluntary, and both you and the state will agree that the recommendation to me should be 20 years to serve, but it's parolable. In other words, they remove that recidivist notice. So you get credit for the time you've been in, and the recommendation, it doesn't bind me. I could give you less. I don't have a lot of leeway to give you more, but I don't know anything about your case, so I'm not telling you I'm going this way or that way. But the state would remove that recidivist notice, so it's parolable. So 20 to serve, credit for the time you've done, if it's negotiated with the possibility of parole. Do you have, I'm not asking if you like it, I'm asking if you understand it.
I understand.
Okay. The other option, if you want to enter a plea and want that state to take the murder off the table and put voluntary on the table, would be non-negotiated. So Ms. Wood could argue for 10 or 5 or 1 time served. She could argue for that. The price of giving her the flexibility to argue for less than 20 is that the state's not removing that recidivist notice. And so whatever number I do give you, you do to the door. And so I'm making it up. Ms. Wood argues for 5, state argues for 20. I hear about your background, what happened in this case, and I say 15. You'll do 15 to the door. So one option is 20. You know the number, everyone's arguing for the same number. I can't give you more than 20, that's the max, but you're eligible for parole. Option 2 is Ms. Wood can argue for less. Mr. Abate can't argue for more than 20, that's the most, but there's no parole. And there's always option 3, and that's that you go to trial. But you need to remember what I started with, which is if you're found guilty at trial, it's life without parole. I have no flexibility on that because of the recidivist notice. So if you hear a jury say guilty, we'll have a sentencing hearing, but you know what I'm going to say, die in prison. So I needed to be confident you understood those things. Ms. Wood has been very good at letting me know that you're struggling with this. I would struggle with this because none of the numbers is a small number. They're all big numbers, and it's your time, not anyone else's. The clock that's running is trial is coming soon, and the state's not going to leave this offer sitting out there. So I need to understand if you are going to go with number 1, the negotiated possibility of parole, you know what the number is. Number 2, no possibility of parole, but Ms. Wood could argue for less, or judge, you know what, let the jury decide. I'm okay with any of those. I'm here for trials. I'm here for pleas. It is your show in that respect. You decide which of those 3 is the right thing for you. And I know you want option 4, which is 2 or something where you can get out of here and go home and you have places you want to be. But you didn't hear me give you that option. So I need you to share with me. If you want to talk with Ms. Wood a little bit more, we got the rest of the afternoon. But if you leave here today, I'm assuming, Mr. Abate, that offer is not out there anymore. Okay, so.
I had forgotten that he's off the charge of robbery, and he admits to robbery. Taking the cellular phone of Miss Patricia Howard So, but I'm willing to do away with that basically.
My understanding was that this all would roll into the 20. Really, the counts don't matter so much. You could run robbery concurrent with that, but yeah, okay. I'm focused on the numbers as opposed to the names. We hang on them, Mr. Dandridge. So, would you like more time to talk with Ms. Wood or think alone on it, or you already know what you're gonna do?
I'd like more time to think alone on it.
Okay, so we shut down at 5, so you got 1 hour and 28 minutes.
I don't want to take a plea today. I came here to take a plea, what she had offered me at the jail, but then when I got over here, it was something totally different.
Okay, well, maybe Ms. Wood can.
When I spoke with her outside the door right here, she said she never said that to me. So you lying to my face.
So before you start saying people are lying, it sounds like there was a miscommunication of some sort.
It wasn't. It was clear cut.
Okay,
Clear
well,
conversation.
all right.
That's why I came over here to take that plea, but all that 20 years and all that, I can't do all that. I'm like 50, 55 years old. I'm gonna die in prison.
Well, I'm sure that Ms. Wood has talked to you about.
Mr. McBurney, Judge McBurney. That man, I didn't kill that man purposely.
Okay, don't talk about the facts of the case.
I didn't kill that man.
I'm hearing your words,
I had to
but
defend myself.
okay. You already had a hearing in front of another judge where the judge got to see and hear the dynamic, and from the bench, he didn't even have to think about it much. From the bench, he said, I deny the immunity motion. So I understand what your defense is going to be. It's going to be self-defense. You're 0 for 1 on that. Judge Dempsey, who has been a judge about as long as you've been alive, was underwhelmed by that argument. And it's not because of the lawyer, it's because of the evidence in the case. Witnesses testified, they're not going to change their story now, they're locked into certain testimony, and you got a sort of dry run of the defense.
The witnesses were stating the same thing I stated, from crossing the I's to dotting the T's. That's why I don't understand why I wasn't granted immunity.
Well, because other people are hearing it different than you see it. And that's a good test run of what a jury's going to do.
My thing is, the witnesses was there. I was there. These people wasn't there, but everybody want to throw deals at me, and they wasn't even there, and they're not listening to the witness, what the witnesses is saying. The witnesses is saying the same thing I'm saying. I turned and walked away. I didn't want any problem, and I got busted in the back of my head. At that point, I had to defend myself, because if I hadn't, I would be dead.
Okay. That may be something you want to tell a jury, but I can't resolve that one for you. And so you told me you're not taking a plea today, then we don't need to weigh you down anymore today, and we'll get this ready for trial. It'll either be on the 24th or the 31st. Ms. Wood, was there anything else you wanted to add?
No, Your Honor.
Okay.
I would just invite the defendant to listen to the witness he called, Mr. Godfrey, during the immunity motion. The minute the police showed up in the body cam, he said that the defendant.
Mr. Godfrey said?
Yeah, Mr. Godfrey, said that he, the defendant, physically attacked the victim, Mr. Buchanan. And that's what led to the physical exchange, as Mr. Buchanan was protecting himself when he hit the defendant over the head. So that's what the eyewitness, the other person.
I was physically protecting myself.
Okay, Mr. Dandridge, we're not going to have a back and forth.
Protecting myself from Mr. Buchanan the whole way.
Got it.
The whole way through.
All right, he's good. We'll see you on one of these Mondays. Be ready to go.
Edward Boseman. Yes.
Ms. Wood, did Ms. Primovic get a chance to speak with Mr. Dandridge?
So she was tied up, and then Ms. Feely was gonna come assist, and then that also didn't work out, so.
Meaning she didn't make it, or the conversation didn't work out?
Well, yeah, there was a miscommunication, so she went back to the office and it kept her in time.
Okay.
That's the way that.
Tell me, what did he think offer was?
We had been, the non-negotiated aspect is what we asked for another.
Sure.
I've made it clear that what I asked for is not what the state will be saying during a non-negotiated.
Got it. And when the state's negotiated offer wasn't what you'd be asking for in a non-negotiated posture, he got frustrated.
Yes.
Got it. Okay. Well, there we go.
I'll leave it up. At least talk to him.
All right. I'll add him to this list. And I'm assuming Mr. Abate, so Ms. Nix knows what to plan. If we reach Dandridge, either on my calendar or is now the only thing left of mine on the Emerson calendar, we'd go forward with a murder as opposed to this sex offender registry violation.
I think, yes, the record most easier to try, but yes, we try.
Okay. All right. So you don't need to worry about your case, Ms. Nix, other than if everything's resolving. You bet. You, Mr. Boseman?
Yes, sir.
Good afternoon.
Good afternoon, sir.
Mr. Boseman, Ms. Rios tells me you are ready to enter a plea. Is that right?
Yes, sir.
Okay. Ms. Dilligard's going to put you under oath, ask you a bunch of questions. Please answer those truthfully and completely. And also please let me know if you have any questions. Will you do that?
Yes, sir.
All right. Ms. Dilligard, when you're ready.
Mr. Boseman, please raise your right hand to the best of your ability. Do you swear or affirm that any statement or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can lower your hand. Please state your true and correct legal name for the record.
Edward Lee Boseman, Jr.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you and how far have you gone in school?
51, GED.
Do you understand that you've been charged with the following offense? 1 count of aggravated assault, possession of a firearm during commission of a felony, and possession of a firearm by a convicted felon.
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
You understand that if you plead not guilty or remain silent or refuse to enter a plea, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had enough time to speak with your lawyer about the charges in this indictment, including the facts and circumstances related to those charges?
Yes.
Do you need any more time to discuss the case with your lawyer?
No.
Are you satisfied with your lawyer's services?
Yes.
Counsel, do you waive formal reading of the indictment and waive any and all defects for purposes of the plea?
Yes.
Mr. Boseman, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge which you're pleading guilty to today? For count 1, the range is 1 to 20. And Judge, we are submitting a no pros for count 2 and 3. If we were to proceed on those charges, the range for possession of firearm during is 5 years consecutive. And for firearm by convicted of felon, the range is 1 to 10. Is that your understanding of the minimum maximum of the charges?
Yes.
You understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court. Judge, the recommendation is to proceed on count 1 for a sentence of 2 to serve 1, with the condition that the defendant receives mental health evaluation and any treatment as prescribed.
So it's 2 serve 1 balance probated?
Yes, Judge.
Okay.
My apologies.
And is it that he have an evaluation or that he have, how would we know if Mr. Boseman ought to get any counseling or treatment or?
So the intention is for him to, when he's on probation, when he is released, to seek mental health evaluation and treatment as prescribed.
Got it.
And then if there is no treatment prescribed or he finishes the treatment that is prescribed, then the balance of the probation can be terminated.
Okay.
Is that your understanding of the recommendation?
Yes, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the plea you were expecting, you have the right to withdraw your plea of guilty?
Yes, ma'am.
Can you speak up a little bit for the court reporter?
Yes.
And are you currently on probation or parole anywhere?
No.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
You understand that if you're on probation, you must follow the special condition of your probation.
Yes.
You understand that if you fail to follow the special condition of your probation, then you'll be subject to revocation of that probation for the balance of your sentence.
Yes.
You understand that you are not allowed to possess or use a firearm while on probation.
Yes.
Are you a United States citizen?
Yes.
Are you asking me to be treated as a first offender under the First Offender Act?
He has a conviction out of Clayton County from 2009, possession of cocaine.
Okay.
Oh, no.
He has at least one conviction.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you're in fact guilty?
Yes.
How do you plead to the charge of aggravated assault and indictment number 24 SC 003258?
Guilty under the effort.
Are you pleading guilty because you have decided that's in your best interest to do so?
Yes.
And are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Is your guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
And do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes.
And do you understand that for a felony charge, you only have 4 years from today to file that petition?
Yes.
Judge, if this case were to proceed to trial, the state contends that the evidence would show that on December 18th of 2023, officers responded to the MARTA train station in reference to an aggravated assault involving a MARTA bus operator. The operator told officers that this defendant was outside of the bus yelling obscure words to him. The victim then said that the defendant walked to the front of the bus, pulled out what looked like a firearm, then lifted his shirt and displayed the word "wanted" that was across his shirt on the front. The incident was semi-captured by surveillance video. You see the defendant outside of the bus. You can tell that he's having some type of verbal dispute with the operator of the bus. My concerns is that he was having some type of mental health issue or maybe was inebriated at the moment. You see him reach into his pocket, but then he goes out of frame. You can also see that when he reaches into his pocket and lifts his arm, you can't see what's in his hand, but you can see that the MARTA bus operator jumps at the same time. Judge, the reason for, and all this occurred in Fulton County, Georgia, there has been several attempts to contact this victim as well, but unfortunately we're unsuccessful.
He's a former MARTA bus operator?
Yeah, and we tried the line from MARTA, we tried the line, personal line, we just haven't had any success, unfortunately.
I've never carried, I ain't carried a gun over 15 years.
Okay, we'll talk. I promise I'm gonna talk to you about that.
So Judge, that's partially the reason for the recommendation that we put forth, the reason for the wonky sentence, suspended, if it's because I just really feel as though I wanted to do some probation on the back end to ensure that he got some mental health evaluation.
Got it. Okay. Let me check one thing.
And Judge, one more thing. I'm
Yes,
sorry.
ma'am.
Just want to put on the record that the only felony conviction that I do see now looking at notes is the cocaine conviction from 2009. So it's pretty old. However, there are several misdemeanor convictions that I'm sure you'll hear about. And so that was also taken into account when making a recommendation.
Got it. Ms. Jackson, criminal history information on Mr. Boseman, please.
He has 43 cycles. The last arrest was May the 18th, 2021, out of DeKalb County for criminal trespassing. He does have one prior felony conviction. It was in 2009 out of Clayton County for possession of cocaine. He does have misdemeanor convictions and sentences. This one in 2021 out of DeKalb County for criminal trespassing. It's an additional one in 2021 out of DeKalb County for the violation of a family violence order. It's one in 2019 out of DeKalb County for criminal trespassing. One in 2018 out of DeKalb County for the violation of a family violence order. One in 2017 out of DeKalb County for possession of marijuana less than an ounce. One in 2012 out of DeKalb County for habitual violator. And in 2009, he received a nolo contendere sentence out of Clayton County for obstruction of an officer and battery family violence. And he received a nolo contendere sentence in 2008 out of Clayton County for obstruction of an officer and simple battery. And there was a conviction in 2005 out of Clayton County for a DUI and driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you. Ms. Rios.
Yes, Your Honor. Mr. Boseman is 51 years old. He has had two children. One is deceased. He has one living child who's 31 years old, and he has one grandchild who's 11 years old. He was working for the Ultimate Car Wash and believes he can go back to that job once he's released. And he is residing in Atlanta, living with his cousin. He did want to explain about the Alford plea. He's saying that he did not have a gun and that the martyr bus driver was mistaken. I watched the video and I at no point did see a gun. But he does understand it will be the martyr bus. I can't remember the complaining when it's in his word, against each other. So he thought it would be better to accept the plea in this case. And we just ask that you accept the plea as negotiated. If you do remember, he did have an evaluation and they said he was fine, but he is willing to have another evaluation and follow treatment if they deem he needs treatment.
Okay, hold on one sec. Thank you. Mr. Boseman, do you remember this incident?
Well, actually, when I looked at it, I seen it, but it looked like it had been dubbed. It looked like it had been played with or something, like somebody.
Well, assume it wasn't played with. Assume you and I'm not worried about the gun. I heard you say you haven't had a gun in 15 years. Right. So that's not why I'm asking. I'm trying to see if you remember so you could help me.
I remember.
What were you guys having a beef about?
It wasn't a beef. when I walked up to the bus, she said, you can't get on with that beverage you have in your bag. I said, well, ma'am, I have it in the bag. She said, it is open, so you can't get on. I said, okay. And I walked away. And that was it.
Okay. What was the beverage?
Well, it was a beer.
Okay. You have been arrested and it sounds like got some misdemeanor convictions in the past for violating a family violence order. Talk to me about those.
I was in a 23-year relationship. And me and her used to get at it sometimes and fuss and argue, and I should have got out of the relationship.
Are you out of it now?
Yes, 4 years now, and I'm glad and I'm happy and I'm going on my life. I wasn't expecting to be back in jail no more ever in my life, Your Honor. I really don't even drink, to be honest. If I drink, it'll be on the weekends, but now that I work on the weekends, I be off on Mondays and Tuesdays. I don't even really drink. I barely even drink, but now I'm going on my life. I feel good. She's not in my life no more. I can just go forward.
So all the family violence orders and this and that was you and the woman with whom you had that long-term relationship?
Correct.
Is she the mother of your child?
No, sir.
Maybe that's why the relationship didn't go so well.
Well, that's why. Because she used to be a jealous woman too. She was very jealous. And
she might have had a reason to be, but okay. When did you last work at the car wash?
Before I came here.
So you've been here for over a year.
For a year.
Tell me why you think you can go back to the car wash.
Because I'm a good worker and they like me.
Okay. And you think the car wash is still there?
Oh, of course, it's the ultimate call where I sit on top of the hill on Camp Creek. We
Okay.
get plenty of business.
Okay. Ms. Rios said you'd be living with your cousin when you get out. What makes you think you can still stay there?
Because I've been there with her for a while.
Okay.
And my grandfather, he passed away out since I've been in here. And my grandmother passed away in 2014. So I know she's missing me and she's gonna need some help paying the bills, so.
Okay. So you think you'll be able to get back to work and earn enough to help support that household?
Yes, sir.
Okay. Do you have any questions about anything we discussed?
No, sir, just ready to get out of here. It's been kind of scary since I've been in here. Been like 7 deaths on 5 North, and it's been really messy.
It's a tough place to be. And that's a reason not to go back, which will be a reason to, if it was beer in a bag or medicine you didn't take, something got you sideways with this bus driver. Bus drivers don't just out of the blue call and say something scary happened. So I just want to make sure, like you heard Ms. Dilligard say, we're setting you out in a way so you don't go back to jail. You've been arrested a ton of times, but not for crazy stuff. You're not robbing and shooting.
I don't do that.
But when I work with someone with that number of arrests, it often says that there's a substance abuse issue, alcohol, weed, coke, whatever it is, or a mental health issue, or both. And I want to make sure that we are providing you support if it's either or both of those. And you know better than anyone else why you have had 43 different arrests. And it's not because the police pick on you. That may be a piece of it, but that ain't 43 arrests.
I think some of those are like double
They are. You got arrested for this and you violated your order, but it's still a bunch of arrests. And so you just need to make sure you're being open with me about, you know what, Judge, behind a lot of that is I drink too much, or
actually it was because of my relationship. She was very, very jealous, and I mean, she get upset.
So you were having babies with other women?
Well, no, I had my kids before I got with her.
Oh,
yes, it was before I got. Well, I was with my kid's mother like 16 years. Then after we separated, I got with her.
Then you got into this long-term relationship.
Yes, like 25.
All right.
25. I got in.
I painted you with the wrong brush. I apologize.
Yes, but she was still jealous. I wanted to keep my kids and stuff like that. And she was,
that's a different type of jealousy. Got it. Okay. Well, Mr. Boseman, I find there's a factual basis for your plea, and I will accept it. I also understand why it's an offered plea. There's this gray area of what did you have in your hand? And frankly, it doesn't matter. Even if you were just like held your bottle in a certain way, that's enough for a bus driver to say, I was worried he was going to hit me with a bottle. So it doesn't need to be a gun to support this allegation. So I'll accept your plea. I find that your plea is knowing and voluntary. Knowing means you've understood everything. And we've had I think a real free-flowing conversation. Voluntary means no one's forcing you to enter this plea. Do you agree with that?
yes, sir.
I'm sentencing you under the Probation Options Management Act. If you have a small issue on probation while you are under sentence, you and probation will address that. If it is more substantial, any arrest, anything like that, that comes back to me and I will address that.
Yes, sir.
Ms. Dilligard, can someone in my office sign the indictment?
Yes.
For you? Ms. Rios, for you? And can we sign for you, Mr. Boseman?
Yes, sir.
All right. Do you have a weapons carry license?
No, sir.
Are there any outstanding family violence orders, or those have all expired and you don't go around that young lady anymore?
No, I don't go around. It's expired.
Okay. All right. I'm going to sentence you on count 1 a little bit differently. I'm going to sentence you to 3 years to serve 1. It's still 1. You've already served a year. You'll get out. Balance probated. So it's a little bit longer probated term, but I'm going to explain why. 1, you'll need to submit to that mental health evaluation and follow any course of treatment if any is recommended. But if none is recommended, then I'm going to encourage that it become non-reporting. But I want to be comfortable that this history of 43 cycles is done.
Okay.
And so a little bit longer supervision gives me a chance to work with you. If 6 months from now we're together again, you're like, oh yeah, I guess I wasn't done with things because I picked up this kind of case.
Right.
I think it is instructive that it's just one felony. That was a drug felony. Everything else has been super low level stuff.
Right.
And you may well be done. I just need to make sure those chapters are closed.
Okay.
And so I'm adding a little bit more probation. It's not onerous. There aren't any other conditions. I will waive your supervision fees for the first 3 months so you can get back on your feet. Hopefully you can get back to that car wash, but even if you don't, that'll give you time to get a job before you have to be paying a little bit. They're not high fees, but before you have to be paying a little bit to probation. Okay? Ms. Dilligard, anything else on behalf of the state?
Yes, Judge, just one thing, and I don't have any reason to believe that he knows the victim in any way, but just to put in a condition of no contact with the victim in this case.
Okay. I had as the victim from the indictment, it said Milton Jackson, but you were describing the bus driver as being female, and Milton could be a female. What do you have as the victim's name?
Milton Jackson.
Okay.
But from the video,
Okay, doesn't matter. That bus driver you need to stay away from. That doesn't mean you can't ride MARTA.
Yes, sir.
But if for whatever reason you get on a bus like, oh, it's you again.
Okay.
Take a different bus.
Yes, sir.
All right, that'll be better for everyone. So stay away from Milton Jackson, get that evaluation, any treatment if recommended. And I think that is it. Ms. Rios, anything else?
Your Honor, thank you.
Last thing, Ms. Simpson is with probation. She's not going to be your probation officer, but she is going to be your probation instructions officer.
What zip code do you live in?
303-17, 16, 17. I think it's 17.
We just need to know what county the place is in because that will
Oh, it's
depend.
Fulton County.
You're pretty sure it's Fulton?
Yes.
Okay.
So your reporting date will be March the 18th.
Okay.
And you're going to report to the Atlanta office. That's going to be 276 Memorial Drive. That's about 5 minutes from here. So you're going to report there. Make sure you show up at 8 a.m. because that is when they start intake.
You said 276 Memorial?
Yes.
Could you write it down for me, please?
I'm writing it down.
I'll provide you with instructions as soon as we finish.
Okay. Thank you.
So don't miss that reporting date because then you're starting out with them issuing a warrant and then we're starting all over again.
Okay.
All right?
Yes, sir.
That's it. Thank you.
Thank you.
Come on.
Okay.
Ms. Wood, I haven't heard anything about Ms. Hanholt. It just dawned on me. That's the last name I got on my list.
Last but not least, Judge, so we'll bring her out.
Well, before you do that, tell me what to expect. Did she take the Laffy Taffy?
She still wants to try,
All right.
and yes.
Has she been offered time served? Okay. Let me just sign this paperwork so this gentleman can get out of here and then we'll do that. Wow, I wonder how you pronounce that person's first name. You know the one I'm talking about?
Yes, sir.
That is a fascinating name. You can come on up. Thanks. Seven. So what's is she just pleading to the indictment and it's time served plus some probation, just time served?
Yes.
Time served, go home or go over wherever she's going next.
Right.
Is she in the state system?
Yes. He is here from Arendelle.
Okay. Let's bring Ms. Hanholt. All right.
I think she's gonna ask you about, I don't think you're gonna be able to do anything about this, but she has an issue with her uniform at the Fulton County Jail. So I'm just previewing that for you, Judge. She wants a two-piece. She's in a.
Well, she won't be here very long, so we can fix that. Do you have a sense of how much time remains on her state sentence?
She is there until 2031, right?
It expires March 4th.
No, I can't, I'm sorry.
Okay. We can at least take care of her final plea rights today.
Yes.
Ms. Dilligard, is Ms. Ford now, as soon as we can get her here and Mr. Luemba here, we can handle that?
Yes.
Okay.
Oh, wait, where were you plugged in there?
Have you admired those new plugs
I was wondering where they came from. When did those get installed?
earlier this week?
There was a plug right there.
It's brand new. It's so you don't have to go underneath there anymore.
Yeah.
Were they making you, they didn't tell you and made you plug in underneath? You're being hazed.
She was like looking for her tooth.
I was gonna say her tooth was under there. Like, wait, it's got me somewhere. Oh. Yeah. Yeah, and it has USB ports as well. You can charge your phone, all that kind of stuff. All to make 8D a warmer, a kinder and gentler space. Good afternoon, Ms. Hanholt.
Good afternoon.
It's good to see you in person. I've seen you on a screen the last couple times, but you are here because you made it onto a trial calendar. And we need to do a couple things on my list, and then I'm happy to hear if there's anything on your list.
Okay.
My understanding is that you're now in state custody, Department of Corrections, on some other matter, with a sentence that in theory would take you through, I think, 2031 or something like that. I'm sure you're parole eligible. I don't get in the middle of that. But it was just explained to me that you may be in state custody for a while, and we'll get you back there soon. You're on the trial calendar. And so we either were going to resolve your case by way of a plea or a trial. You, through no fault of your own, weren't able to join us last time. I think it was a technical issue. But last time was a final plea. And so I want to make sure we go through the final plea conversation at a minimum. And that's when I'm going to ask Ms. Dilligard to put on the record what the state's offer is to resolve the case short of trial. I'll make sure you understand that offer, and you can say, great, I want to do it, or no thanks, I want a trial, or whatever your answer is. Today, if you were to pursue a plea and I were to sentence you more severely than what Ms. Wood asked for on your behalf, you'd have the absolute right to withdraw your plea. So just to make it up, Ms. Wood says, give Ms. Hanholt time served. And I think, this is her, also making this up, this is her 5th case. And so I'm going to say it's 3 years to serve. You could say, no, thank you. Time served was something, or 1 year was something I was willing to take, but you've sentenced me to more. No questions asked, you withdraw it. That's nothing that ever gets shared with the jury. If you are not interested in whatever the state's offer is and say, no, thanks, I don't want to enter a plea today, you, 1, can always have a trial, but 2, if you decide later on, it's just not worth the trial, I'm going to enter a plea, we can do that. You just don't get to withdraw your plea if my sentence is different from what you had asked for. So that's the big change, is no right to withdraw your plea. Do you understand that?
Yes.
Okay. Ms. Dilligard, if Ms. Hanholt were to plead today, what would the state be recommending?
The state's recommendation is time served, Judge.
Okay. And do you have a rough sense of how much time that has been? I'm sure Ms. Hanholt has a very good sense, but I'm curious what your records show. And it may be hard to tell. I know Ms. Hanholt was in a different jurisdiction and then now in state custody. She was arrested in this case in 2023. Did you ever get out, or have you been bouncing from jail to jail?
I have not gotten out.
Okay. I'm looking into our system to see what it says. You were here for 17 days, went to another agency, then came back for 27 days to another agency.
I was just in Cherokee
Cherokee, cycling through, and then again, so I see the point. So you have not been out of custody since at least October 23. You may have been in before then.
Yeah, I went in August of 23.
Okay, and have been going from local jurisdiction to local jurisdiction.
And I've cleared everything.
Okay, well, cleared everything except you're in state custody now for.
I'm in state custody for violation of probation because of Fulton County, so.
Okay, either way, if clear means there aren't things in other counties, I hear you.
Yep, I got my paperwork dismissed, everything.
There's just that hot date you've got at Arendelle where you'll be heading back. Okay, so my question means a lot less now to you, Ms. Dilligard. I understand the route Ms. Hanholt has been taking. So it's time served. Is that something you're interested in pursuing?
Absolutely not.
Okay. Tell me what you think going to trial would do for you other than expose you to a consecutive sentence that I could impose.
I'm innocent in this case, and so.
So why plead?
What? Pardon?
So why plead? I mean, if you're innocent, why would you plead?
I'm not pleading. So, I mean, we have pictures of the girl. She looks nothing like me.
We don't need to get into that. I'm not doubting you in any way. My question was sort of rhetorical, but if.
So I've been back to Cherokee County since I've been in custody, and they sentenced me with this case, but the judge has had a moment and she has brought me back. So we want to get this case taken care of, and then I have another court date in Cherokee in April 8th. And once this case is resolved, then they will review I would not be eligible for violation of probation anymore because I didn't violate my probation. So I would be eligible to be released from prison. I've worked very hard on my innocence. I have not been to county and have had the counties, DeKalb County dropped my charges, Forsyth County dropped my charges, Rockdale County has dropped my charges. I just got a letter from Forsyth County and there was an order and they have dropped my charges. I am 100% innocent in this case. So I'm willing to go the distance.
Great. This
is the only one that has not. This is the only county that has not really looked at the evidence in the cases and dismissed.
Do you have a theory why you were indicted in so many counties? Someone using your name?
Yes. No. So what happened is my son, unfortunately, he was murdered in 2023.
Sorry.
He and a girl went and wrote a bunch of my checks around the state of Georgia prior. He used to be a police officer, but he got into drugs and stuff. Then he was brutally murdered. Still do not know who murdered him. So I was a a victim in the case. So when this Fulton County case came up, and if you can read my police report, when they sent out an alert for like a BOLO alert, they said, it says the detective in this case said it looks like the victim in a fraud case I am handling. And then that is how I got involved in this case. I've never seen this girl. I do not know this girl. I don't know anything about this. Even in the police report, it stated when he sent out the DDS facial recognition, it said that came back that it was not me in the facial recognition. So this is just the only county that's prolonged this is the only county where we've gotten this far.
So I'm confused a little bit by what you said. What I heard you say is that your son and a young lady with whom he was involved used your checks and.
My checks, yes.
Right. You're charged here with being Barbara Wolf.
Yes.
That has nothing to do with your son or your checks.
But it does, because when they sent out the BOLO alert, they sent it out and the police officer came back as a victim. So then they put my photo in a photo lineup, and that's how I got involved in this.
Okay.
It just on a BOLO alert that came out for a completely different situation.
Okay.
And then they used my picture in a photo lineup. And the bank teller lady said she was only 80% positive that it was me. I mean, they said she's.
I don't want to dive into the facts too much. I just was trying to understand, because I know you have been doing the rounds with all these counties, and I think you can understand why I'd be confused how you could manage to be indicted in so many different counties.
I was never indicted in those counties.
Oh, what are they dismissing? Just arrests they're dismissing?
Yeah, they're just dismissing and just the arrests.
Okay.
Mm-hmm.
All right.
Yeah, you want to see the order from Forsyth?
I don't. That's something that Ms. Wood will share if she thinks it's in your best interest with Ms. Dilligard, not with me. Ms. Wood, it's been helpful to hear from Ms. Hanholt. Is there anything that you want to add to the situation?
No, Your Honor, I would just for scheduling purposes, I don't know if we'll get to her on the 24th.
Well, I'm going to talk to her about
Okay.
that because she seems anxious to resolve her case, which I appreciate. Have a jury hear it all and hear whatever there may be in terms of 404B and all that. But I just wanted to know if there was anything else you wanted to add.
No, Your Honor, thank you.
Okay. Ms. Dilligard, and you've got all Ms. Wood, you've got all the discovery in the case?
Yes.
Okay. Ms. Dilligard, anything you want to add?
No, Judge.
Okay. So Ms. Hanholt, I have 1, 2, 3, 4, 5, 6 cases ready for trial. Up now 5 because this gentleman just pled. And you are one of them. You have not been in jail the longest of all those folks. And I typically start with who's been in the longest. So it is entirely likely that we don't get to your case on this calendar. If we don't, I'm going to send you back to Lee Arundel. We shouldn't be keeping you here when you're in GDC custody unless we absolutely need you, and we would need you for trial. But because you are in custody, we'll get you back on another trial calendar soon. And I heard you loud and clear what you want to do, which is have a trial.
Okay, so did I waive my right to a speedy trial?
We didn't file a speedy trial demand in this case.
So you can ask me, and Ms. Wood has already done this on your behalf, hey, could we try to move Ms. Hanholt's case along? But to invoke the statute for speedy trial, there's a particular time frame, and you're outside of that. So there's something called an out-of-time speedy trial demand, which has basically as its effect, Judge, could we please prioritize this one? But Ms. Wood's been asking for that on your behalf anyway. So I will stay focused on your case to figure out how we can get it resolved sooner rather than later. If we don't get to try it, it's not next Monday, but the Monday after, like I said, you only move up in the list, but I have a couple defendants who have been in custody, believe it or not, longer than you have. So that's where I would start. and then I would get to your case.
So I'm gonna go back to prison and then come back here again? I can't just stay until we do trial?
Well, I'll talk with the sheriff about that, but there is a cost associated with keeping you here. There are risk factors, not because you're risky, keeping you here. And there is also just your home base right now is Lee Arundel, and we are borrowing you. And usually the institutions say, you need to send someone back to us if you don't need them. If my next trial calendar was the day after this one ended, we'd keep you here. I'm not interested in having you have a whole bunch of bus rides. But it is appropriate for you to be at your home institution until we're in a position to say, no, now we got another trial calendar.
All right, can you give me a guesstimation of like time frame? Because I slipped down some stairs at the prison and I broke both my wrists.
Ouch.
So I have to get surgery on this one. So what's like the time frame? Like, see, I wanted to get this done before April 8th because I go back to Cherokee on April 8th. And I wanted this resolved.
I hear you. You raised that date when you were talking to me about the circuit you've been doing with all the local counties. It won't be before April 8th. So if you in fact have a hard and fast date there.
I do.
I'm not doubting you. Then Cherokee will do a production order with the Department of Corrections, and they will get you from Lee Arundel to Cherokee for that date. We won't be the reason why you missed that date.
Okay. But the reason it was scheduled for Tuesday, March 11th, but I had them change it because I didn't understand. I thought I was really going to trial today. Like this, I even sent her my outfit sizes.
Okay. And it's good you did that. Now she's got them so that you can.
But, so I've been in custody for 20 months. Once I resolve this case, then I possibly could go home. So what is the guesstimation? So then I can tell Jeffrey, my lawyer in Cherokee, to push it out because I want to go to Cherokee County with no cases.
Got it. Or, because of course you could go to trial, and if you're found guilty, you'd be going to Cherokee County with a conviction.
I'm not going to be found guilty.
Well,
I'm not worried.
I admire your certainty.
I'm 100% innocent, so I have witnesses, everything.
Okay.
So I'm not worried at all.
So Jeffrey should talk to Ms. Wood. She'll be able to look at our trial calendars and say it's most likely going to be the May calendar or whatever. But it's soon. It's not going to be this fall. We'll get you back on another one.
But it will be by June.
I can't commit to you that, Ms. Hanholt. I have specially set trials where 4 defendants have been in jail for 3 years accused of murder, and they say they're innocent as well. That is almost double the time you've been in. So I hear you, and I am working to move your case along. Okay?
Okay.
All right. Ms. Wood, anything else?
No, Your Honor, thank you.
All right. I hope your wrists feel better.
It sucks. Oh, yes, there is one more thing. I'm sorry. Oh, I am really sorry. I need you to order, I don't know how long they're going to take me back, how long it's going to take me back to get back to Lee Arundel. Only if you order me to go back immediately, it will take like a month because that's what the norm is normally. I need, if you possibly can, I know this is the weirdest request, if you could court order me for them to give me a two-piece outfit because I cannot go to the bathroom and then button this up. I had
the wrists.
I had her help me in the hallway because I can't.
It is not a weird request. It's a reasonable request given the
Yeah, and I asked her this morning and she had an attitude with me, the officer did. And I know they have them because I've worn them before.
Okay.
But if you could give me
So we'll do one of two things. We'll either find out that they can get you back to Lee Arundel ASAP. And if the answer is no, the next bus is a week and a half.
Yeah, they usually
then-
transport on Wednesdays.
Okay. All right. Thank you for flagging that. I'll make a note of it.
All right, thank you. And you're gonna put for the two-piece though?
If they cannot commit to me that you're heading back to Lee Arundel right away, then yes, ma'am.
Okay, all right, thank you.
Mm-hmm. You are 0 for 2 today, Miss Wood. Dandridge, meet Hanholt.
We should change numbers in the.
That's right. That's right. Although you did have Larry Lawson.
Just didn't mind Larry Lawson. He at a core, he's a good guy.
Yes, he treated you poorly. And maybe away from here he didn't, but
He's come to my office. He was really nice to me in the office.
he was nice the other day when he surprised everyone by showing up.
Yeah, like he just gets. I blame the TBI.
I'm not buying it.
I know you hated him, but
I don't hate him.
No, I'm with you.
All I saw was the hype thing, and I was just like, poor Miss videos.
well, I'm sure than most people, so I'm like used to it.
No, but you talking about that, like, okay with that, I should.
Yeah, I was definitely scared. I really should be, but I'm really scared of my life. Only been once because he like specifically threatened me. But other than that,
So let's go over the calendar to figure out what's still around. But are there presiding, is stuff back with Ms. Niles? I don't have anything yet, so she's processing it. Okay, great. We're not ignoring you all if you're here for presiding matters. All right, so we've got Frazier. Does his speedy run, like we need to try at this calendar?
I think so.
Okay.
This would be the next turn, like the.
I think, because we didn't do it last time, because
Right.
I think you asked for more time. If they asked for more time, we would have been able to say no speedy, so you must have asked for more time. Someone was looking for some magic bullet that would clear it up. Were you supposed to get it from the defense and they didn't get it to you, or you were gonna get it from the bank or the victim?
The victim.
Okay, all right. So that has to go. Mr. Williams, between Williams and Dandridge. Oh, did you say you could do Williams and then Dandridge back to back?
Yes,
Those were your, I'm not putting those words in your mouth. Okay.
I will endure that if I can close out those cases.
That's gonna be a couple weeks. Will Ms. Primovic fly with you on both those?
I think so, if she's available. If not, I'm gonna draft Miss Feely.
Okay, cool. We can, Ford will resolve. Baker is postponed. We rolled over. Holiday, we just wouldn't get the holiday. I don't understand how we got out. I'm gonna figure that out. And that took care of everyone else. So really it is Frazier, Williams, Dandridge, I think. And one of those three will fill the week of the 24th. So sorry. We'll send her back. And then if Williams doesn't, if Frazier somehow resolves and we try Williams, Dandridge could be my Judge Emerson trial if they get to me on that list.
Yes.
Okay. All right. So I'll send an email out to all the lawyers, but what I think that means for you, Ms. Dillagard, is be ready on Frazier. And then Ms. Wood, Ms. Rios, it means enjoy your week. And Ms. Wood means be ready on Frazier and Williams and Dandridge. Obviously, we only try one of them. And it would be Williams if Frazier goes away, and then Dandridge would just be that following week if we get to it. And those emails will start going out either tomorrow or Monday, what the first week of Emerson looks like, but that won't involve you because you'd be here. And we'll see what they slice through. All right.
Sorry, if for some reason, I don't know much about Williams, if Williams doesn't go, then Dandridge goes.
Mhm.
And if that doesn't go, would it be Holiday or?
It would be Hanholt because she's in custody. So I guess we should keep her around. I don't see Williams going away. Dandridge could still come around. He's angry, but he doesn't have options. And so maybe if he marinates a little longer, but
Williams is not going away.
Yeah, no, that didn't get onto, because of our discussion, I didn't put that on the Emerson calendar. So to me, the wild card was this Fraser piece that it broke a different way so far. But we'll keep Ms. Hanholt around, so I'll research the two-piece outfit.
Thank you, Judge.
All right, Ms. Jackson, thank you for being here. Tomorrow is no criminal. So, and then next week I have a civil trial. So Ms. Jackson, I'm not going to see you for a long time. Be safe.
You too, thank you.
All right, bye-bye.